I would like to mention item number 8. On behalf of Tita Box, we have taken consent to other party.
Item
8.
The makes request made by the council body. Petitioner said refer to be listed after weeks,
After weeks.
after 1 week. We submitted consent to the council to respond to the thing.
Lordship, and another matter, item number 6. On behalf of Tita Box, we have consent from other party.
EIL,
Yes, Lordship.
why you are joining your EIL?
Lordship, leading council is out, so
Same order, item 6.
if you
I like to mention item number 9, man.
Yes. Right, criminal appeal. It will be listed next week.
Yeah.
Next week, criminal appeal. Item 9, the request made by the council for the appellant. You are a legal aid counsel.
No, no. Not good.
Item 9. Next week.
Item number 1.
Yes, and my lord, this bill, my lord, in terms of my lord, lottery regulation act, my lord, 1998, my lord, it is the only the state, my lord, who can organize, my lord, lucky draw and housing. My lord.
Who are you?
I am, my lord, a social activist, my lord. I have a
But your petition is not drafted in terms of the High Court rules, EIL rules. You have made a statement that you are capable of paying.
yes, my lord.
What do you do? Are you in service? Are you in business?
Yes, my lord. I have mentioned it in my lord, Vara, my lord. Vara, 5, my lord. 5, my lord.
Now, 5, you have made an just an omnibus statement that you have sufficient means.
No, my lord, herein for livelihood, for farming, my lord, and also to site business in construction and supply have sufficient means.
Secondly, you are the member of some organization.
My lord,
Now, under the rules, you have to give the list of all the office bearers.
my lord,
Have you given the list?
no, my lord, I filed this PL in person, not as an organization. My lord.
You have mentioned it that you are a member of
Yes, I presently member
president.
the president, but this PL, my lord, has been filed in person, my lord. Not as an organization. Now, my lord, will see, it is the only state, my lord. In terms of the egg and rule, my lord, it is the only state who can organize the lucky draw like lottery and housing, my lord. Now, but in Arunachal, my lord, it is been organized by a private person, my lord, without any authority of law, my lord. And rampantly, my lord, on daily basis, my lord.
Yes, Mr. Roton. You should notice, but EIL petition, EIL is filed by the petitioner in his personal capacity. Claims to be a citizen and a resident, claims to be a resident of which place?
Nirjali, my lord.
State of Itanagar. The petitioner is agreed that his rampant lottery dealership, distributorship, and lucky draws organized by persons or associations, which is completely unauthorized and not permitted under the, what is that act?
Lottery Regulation Act 1998.
Lottery Regulation Act 1998. And the rules frame thereafter. This is a state act.
Central Act.
central line. Is there a state rules also?
State no, not my lord. There is a one gambling act, my lord. That but that does not include the lottery. My lord.
They submitted that in terms of that there will be rules from state government who can organize. Council. Yeah, some state, there is a Department of State Lotteries, Government of Arunachal Pradesh, Canada. And however, all these lotteries, the particulars of which are described in the petition are completely unauthorized, as these are organized by private people, government or under some circumstances. CPI by seeking directions to the respondent state, take necessary action in terms of prescription of the act as well as so. The Mr. and the petitioner appears for the state, considering the issues involved, let notice issue, returnable after 4 weeks. Mr. Ratan accepts notice on behalf of all this compensation of the whip, however, extra condition. In a period of 1 year, it's not.
Always.
Item number 2.
My lord, this writ appeal is filed against challenging the dismissal order. Dismissal order dated 20/05/2024 passed by the learned single judge in IA number 32/2024 in respect of Om Prakash versus Union of India. Lordship, the writ petition was filed by the writ petition 114 was filed by the writ appellant before the learned single judge, which was dismissed on Lordship, dismissal order is in page number 162 of my writ appeal on dated 2/3/2024. During it was dismissed on being not pressed.
What is that? Where is that order?
Order is in 162, my lord. Page number 162, last page. Upon instruction, the learner can submit that they did not intending to press this petition.
Then?
Then one IA was filed, IA number 32, which is a challenge in this writ appeal. In that IA, it was read that during the dismissal withdrawal, liberty was not prayed. So prayer was made in this IA 32 for modification and modification of the modification to in dismissal order by incorporating liberty to file a liberty
You
to
want
file.
liberty.
Yes.
Then
So while hearing this IA number 32, the learned single judge has not considered the merit of the IA, but has
where is the impugn order?
impugn order is not at page number 18. Even in the Lordship IA, not even affidavit in opposition was filed. But while dismissing this IA 32, a stand was taken by the from writ petition number writ petition 1114, which was dismissed by counter epidemic. But it was relying on the counter epidemic filed by the file in 114, not in the IA 32.
Yeah, what do you say, Mr. Kato?
The petitioner was facing departmental inquiry.
Not on that. He had withdrawn the writ petition. Writ petition was not dismissed or not pressed, as not pressed.
Yes, ma'am.
Then he filed an application seeking liberty.
Yes.
Now, then what happened?
Then, the IA has been dismissed, as your lordship has already paid you. Even if it is reinstated, the petitioner has been already given on the superannuation. So, his basic claim is for payment of the pay and salary for certain period on which he was facing departmental inquiry. This is absent period. During absent period, his salary was withheld and has not been paid.
Then was it not pressed in the, was it not urged in the earlier writ petition?
Yes, it was my prayer in the writ petition.
Then why did you withdraw it?
I had an instruction to withdraw, but it was for liberty was to be taken, which was missed.
Liberty for what?
To file a press.
Why do you want to file a press if you had already urged in the earlier writ petition?
There was some changes in the circumstances.
What changes in the circumstances?
Which I have no instruction.
Huh?
I have no instruction.
You had filed a petition seeking certain relief.
Yes, Lord.
Then your client instructed you to withdraw, you withdraw. No liberty was granted. You filed an IA in the petition which was dismissed, seeking modification, praying for a liberty. The court wanted to know what was the basis for grant of a liberty. If it is a case that these prayers were not urged, overlooked, then it's a different thing. But if you had already prayed for and you had withdrawn the writ petition, why you are asking for liberty?
Even though the WPC IA 32, while dismissing IA 32, the merit of the IA 32 was not considered. Only the reference was made from the epidemic file in WPC
Where is
114
your IA? Where is your IA?
IA. Page 153. For correction modification of order dated 02/03/2020, passing WBC 114.
I think you are saying that you failed to press for liberty.
Yes, Lordship.
Why do you want liberty? You had urged all these before the writ court and then you consciously chose not to press the petition. Why are you asking for a liberty?
Lordship, actually, this writ petition was conducted by another council, earlier previous council.
So you examine and tell us what benefit
There
we
was,
get.
according to instruction, there was a communication gap between them.
Then you file an application seeking review of the order, saying that under improper instructions, the writ petition was withdrawn.
Only clear is that
We don't find any merit.
notice may be issued.
No. We are dismissing your appeal. You have not been able to explain why you want liberty.
Another date will pass over.
Heard counsel for parties. Yes. Appeal has been filed in challenge the order dated 005/2024, passing I number 32 of 2024 in WPC number 114 of 2018. Para WPC 114 of 2018 was filed by the petitioner seeking a direction from the court for release of salary and other service dues for a certain period of time. However, during the pendency of the petition, on the basis of on the instructions received, counsel submitted before the court that the petitioner did not wish to press the petition according to the statement dismissed. Subsequently, his IA number IA 32 was filed, seeking modification of the order of dismissal of the petition on the ground that liberty was not granted. So, the report upon examination of the prayers made in the IA by the impugned order dated by 2020 declined to allow the IA, declined to allow the prayers made in the IA according to IA. Yes, IA. So, upon hearing the counsel for the appellate, then upon perusal of the pleading available, court see that the prayer in the writ petition was for grant of salary for the period 9/6/2025. The relief was sought for the writ petition, seeking a direction to the respondent authorities for payment of the salary for that period. So, however, subsequent to the instructions received by the petition, counsel appearing to the writ petition submitted to the court. So, the IA also, no grounds, no specific grounds have been urged as to why liberty is required. Re-hear the matter or refile the matter when the basic claim of the writ petitioner for payment of salary for period mentioned 9/6/2015 to 25/2017 was already the primary prayer in the writ petition. So, the counsel for the appellate was unable to address the queries of the court as to why liberty is granted. Liberty is sought for as there is no specific averment in the IA, which was dismissed by the single bench, that certain other grounds were urged, which were paid to be pressed by the counsel. So, the learned counsel for the appellant, however, after arguing the matter for why submits that the matter be taken up after 1 week. Mr. and counsel will then appeal here, not of the prayer. They play out. After 1 week, yeah.
Item number 3.
May I please your lordship, my lord?
Yes.
My lord, in this case, my lord is supposed to file an affidavit along with a missed case for condonation or delay. But the documents which are supposed to annex are not legible, my lord. So it is a huge document, my lord. So I need 3 weeks time to file those, my lord.
The delay here.
My lord, yeah, my lord, there's a delay. The office note says there's a delay. So on the last occasion, normal court said to file an application. But if we say, my lord, as per the my lord, from the date, if we count from the date of receipt of the order, there is no delay. But since that order was passed long back and the matter was received later on at a later stage, the office registry put a note that there's a delay petition not filed. So that's why I was supposed to file a petition for condonation of delay as well as a document, an affidavit enclosing the SOCOS notice and the order in original. But those order notices are not legible, my lord. There's a difficulty I'm arriving at. I have to type it out all these 150 pages. So for that, I pray for some time.
Relevant. 3 weeks.
My
3
lord,
weeks.
highly obliged, my lord.
Item number 4.
Yes, Mr. Patel. That notice issue here. Statutory appeal.
Yeah.
Will you issue notice here?
Lordship, before issuing notice, Lordship, the identity of the victim was not displayed.
Was not.
Explained, Lordship. Not in compliance of the notification number 17.
Respondent 3.
Yes, Lordship.
Well, this is my law. This is not a POCSO case. No doubt the case was registered under POCSO A. And during the course of the trial, the age of the victim was not ascertained. And clearly she has admitted in the cross examination that she has casted vote in 2019 assembly election.
No, but you are convicted under POCSO.
No, I have been convicted only under IPC, not in the under POCSO. The initial case was
Item 5, na?
Yes, Mr. Mazumdar.
My lord, in this case, the grievance of the appellants is that their land has been acquired, award has been passed, but at the time of payment of compensation, my lord, since they are female heirs, they are sought to be denied the compensation, full amount of compensation. My lord, what has happened is, my lord, after the award was passed, deputy commissioner who is authorized to make the apportionment, etc., he has referred it to some village authority. Now, village authority means a society has been formed who is purportedly representing all the villagers. Admittedly, my lord, we are the daughters of those persons who are entitled to compensation, but these fathers do not have any male child. On that ground, they are sought to be denied. Lordship will straightway go to, my lord, page 350, my lord. Lordship has seen, my lord.
Yes.
My lord, before that, I'll just take your lordship to 345 once, my lord. 345, my lord, if your lordship kindly comes to 345. My lord, by this letter, lordship will kindly see at page 346. Lordship is seen, my lord, 346.
Yes.
My lord, this is the letter
The deputy commissioner.
of the deputy commissioner. Now,
Is the
everything.
award.
No, my lord. Award is at page, yes, this is the award, my lord. Now, at page 346, last but one paragraph, it says assessment and verification, etc. But before that, the last point to be resolved while passing the award is the apportionment of the amount of compensation among the affected people. So this was the letter, my lord. Thereafter, lordship will find at 346. I'm sorry, my lord. At 350. 349, I'm sorry, 349. When the deputy commissioner is the person who is to decide who is to get how much of compensation, Lordship can is 349, 11th of January 2024 letter, my lord. Have your lordships got, my lord?
Yes.
My lord, this is the letter which says, it is to inform you that land acquisition proceeding of Italian hydroelectric power 3097 megawatt project had been completed following the process laid down as per rules and guidelines of the Land Acquisition Act. Further, it is to bring to your notice that the final award of the project was published by the District Acquisition Authority on so-and-so 2015. Therefore, you are hereby advised to approach your concerned village committee for any kind of claims and objections in the project affected family, that is PAF's list. Now, Deputy Commissioner is sending us to village committee. Under section 30, my lord, it is to be done by the collector. If the collector fails, it is to be sent to the, my lord, civil court. Your lordships are aware of that, my lord. So after that, my lord, this village community, in the name of representing all the members of the society, next page, my lord, page 350, they have taken a decision, my lord. Lord, will you kindly see page 350. At the bottom, my lord, paragraph number 7. Lordship say, got, my lord?
Yes.
All sisters, widows enlisted by the community will be given 20% of the total compensation amount and shall be equally divided among them. This is the dispute, my lord. Whether the females and sisters, and particularly in our case, my lord, our father do not have any male child. So our father's share will go and we will get only 20%. And the 20% of the amount of compensation has been reserved for giving to all the women. Now, is this permissible under the law, my lord? This is the first question. Secondly, my lord, earlier when I approached this court directed by an order dated 2/4/2025 at page 101, my lord. At page 101. One 103 is the
Yes.
page 103 is the order passed by Honorable Justice Surana on 2/4/25 in the first writ petition. And at page 104, Lordship will find in paragraph 7. Paragraph 7 at page 104, my lord. Insofar as the representation dated 25/10/2023 filed by the petitioner before the DC Dibang Valley district is concerned, the pendency of this petition shall not be a bar for the state authority to dispose of the representation of the petitioner. However, insofar as the share of the petitioners for compensation is concerned, the same shall not be disbursed to any third party. So that was the order. And after this, my lord, our representation has been disposed of, which Lordship will find at page 106. And only 2 paragraphs are relevant, rest are not relevant. at page 107. Second paragraph, my lord. There is no record of evidence that the petitioner has made any claims or expressed their interest in the land acquisition during the period of claims and objections under Section 9 of the Land Acquisition Act, nor for inclusion as project affected family person under Arunachal Pradesh Relief and Rehabilitation Policy 2008. The entitlement of project affected family list of all the affected family was finalized by the Deputy Commissioner cum Collector on the basis of the provisions of under Section 9 of the Land Acquisition Act. Therefore, there is no ground to question the sanctity of the above position of the Act and proceeding thereof. Therefore, under circumstances of representation of Srimati so-and-so, three of others, for enlisting of their name in the project affected family of Aliu and Ajuli community land under the project Italian so-and-so, as paid for cannot be considered hence liable to be rejected. My lord, your lordships, my lord,
This is your claim for equal share.
equal share. They
Equal
are
share.
saying, yes, my lord, what has happened since we are married off, my lord, and we are living elsewhere, we did not have the knowledge. And that is why subsequently when we came and we claimed our father's share, initially they said that no, for all the females you will get 20%. Now the deputy commissioner is changing the stand and saying that see, no. Since you did not raise the objection at the relevant point of time, we are not going to give any share. Now your lordship is lordship, kindly take the Land Acquisition Act for a moment, my lord. I'll just show one small provision, section 11, that will clinch the whole issue, my lord. Section 11.
You're referring to the 2013.
No, my lord. The proceeding was under 1894 Land Acquisition Act, and ultimately, yes, madam. Ultimately, award was compensation was given under 2013, but then all entire proceedings was under LA Act 1894. Lord, will you kindly see section 11, my lord. Section 11 says enquiry and award by the collector. On the date so fixed or on any other day to which the enquiry has been adjourned, the collector shall proceed to inquire into the objection, if any, which any person interested has stated pursuant to a notice given under Section 9, as in this case, my lord, to the measurements made under Section 8 and...
Is there any local customary law operating on this area in so far as that community is concerned?
My lord, nothing. They could not show anything. Even at the level of honorable single judge also, they could not show anything. I'll come to that, my lord. That is second issue. First issue is about not making claims. So it says, my lord, and into the value of the land at the date of publication of notification of Section 4, Section 1, and into the respective interest of the persons claiming the compensation, and shall make an award under his hand of true area of the land, compensation which is, in his opinion, should be allowed for the land. And third is very important. Apportionment, Lord should kindly see, apportionment of the said compensation among all the persons known or believed to be interested in the land, of whom or person or whose claims he has information, whether or not they have respectively appeared before him. Even if I do not appear, compensation cannot be denied to me, my lord. This section is very clear. So, my lord, now, although the society who was purportedly representing all the villagers for the community land, they are saying that since we have reserved only 20% for all the women, so they will get very minimum. Now, the Deputy Commissioner, while disposing of my representation in terms of the order passed by your lordships in the first petition, he is saying that you did not make the claims. And this is contrary to Section 11. Now, second part is, my lord, about 20%. Lord, shall you kindly see one more provision here, my lord. Lord, shall you kindly see Section 30. Your lordships are aware of this, my lord. I am just pointing out Section 30, my lord. If there is a dispute about apportionment, here they are raising a dispute that, see, you are a woman, legal heir, female legal heir, you are not entitled under the custom maybe. But it is for them to show. Lord, shall you kindly see Section 30, my lord. Dispute as to apportionment. When the amount of compensation has been settled under Section 11, if any dispute arises as to the apportionment of the same, or any part thereof, or as to the persons to whom the same, or any part thereof is payable, the collector may refer such dispute to the decision of the court. Court means civil court, your lordships are aware, your lordships have known the law, my lord. So instead of sending it to the civil court, my lord, collector, although initially acted upon the pressure of the society whom I have implemented as response number 4 to 8, my lord, that for female heirs, there is no share under the custom, but still we are reserving 20% for all the women and all the sisters. So they will get very minimum. Secondly, but while disposing of the repayment testament, since the deputy commissioner cannot take this plea, deputy commissioner has changed the stand and now he's saying that you did not raise the claim at the appropriate time. My lord, we are married off, we are staying elsewhere. That is why there is a provision that even if I am not there, you cannot deny the compensation. So far as apportionment is concerned, my lord, if there is a dispute, anybody may raise a dispute. Even amongst the family members, my lord, there are sometimes dispute about the family partition, etc., etc., and my lord share. In that case, your lordships are aware. It is always sent. I mean, Assam, my lord, your lordships have seen. It is to the civil court. You go and decide your share, then you come and you take the compensation. So, my lord, then we approach this honorable court. This honorable single judge has accepted that it cannot be denied that female heirs are entitled, but since they did not raise the objection at the appropriate time, they cannot be granted, my lord. This is the problem, my lord.
There is no bar for you to raise the issue before the competent civil court.
No, my lord, they are raising the dispute. I am not raising. They are raising. The society is raising that I am not entitled. It is for them to show under which custom I am not entitled. I am not raising any dispute. They are raising the dispute.
No. Even forget that 20%.
My
But
lord.
even otherwise, your share of compensation will have to be decided from the total amount of compensation which has been ordered by the collector.
My lord, your lordship is absolutely correct. I am entitled to my full share. Society is saying we are cutting it down to 20%. Is it not the burden of the society to prove before the deputy commissioner? And if the deputy commissioner thinks that I am not entitled to decide,
According to you, what is your share? What
full
should be
share,
your
my lord.
share?
My
What
full
is the
share,
what right?
my lord, as each of the members of the community are getting their share, according to that, I should get my share. Now, the society who is purportedly representing the my lord, members of the community, they are cutting it down to 20%, whether they can do it, my lord. So, if the deputy commissioner thinks that it cannot be decided, deputy commissioner ought to have referred to the civil court and ought to have also passed an order that amount will not be released until you.
This share is to be decided on the basis of the size of your land, which has been acquired.
My lord, there is no
Portion of the land.
my lord, there is no dispute about the apportionment. That I am not disputing. Whatever land I have got on that basis, I must get my full share. The question is they are resting it to 20% and 20% not for me, my lord, 20% for all the females. So all the females of the community together collectively they will get 20%. So each will get very less. Whereas they are entitled to full share as is given to a male person. My prayer is very simple. A male member of the community should get equal to what I am getting as a female. There is no custom, my lord, that female share should be restricted or she should be denied. My lord, I have cited two judgments which says of the Honorable Supreme Court that a tribal woman cannot be deprived of her share of compensation.
Yes.
My lord.
Yes, Mr. Mazumdar, anything more?
Just one judgment, my lord, 2023 3 SCC. I have given a, my lord, lawful kindly see this. 2023 3 SCC 528. Kamla Neti. Just one paragraph I will read, my lord. Para 7.1. Para 7.1, my lord. If your lordships have got, my lord, I read it out, my lord. Before parting, starts with the words before parting.
7.1.
My lord. This is also regarding land acquisition matter, my lord. 7.1. Before parting, lordships have got, my lord.
It's not here. The Kamala Niti you are giving us.
Yes, Kamla Neti. Yes.
Has only one paragraph 7. There is no.
After
The
7,
others are.
my lord, I have taken the
Yes.
printer. My lord, I have taken the printer from Supreme today. After paragraph
Oh.
7, my lord, there is one paragraph. Before parting, we may observe that Have your lordship got, my lord, that para? Para 7 starts with under the circumstances, my lord.
70, it is 70,
Yes, my
before
lord.
party.
Yes,
Before party.
before parting, we may observe that there may not be any justification to deny the right of survivorship so far as the female member of the tribal is concerned. When the daughter belonging to non-tribal is entitled to the equal share in the property of their father, there is no reason to deny such right to the daughter of the tribal community. Female tribal is entitled to parity with the male tribal in the intestate succession. To deny the equal right to the daughter belonging to the tribal, even after a period of 70 years of the Constitution of India, under which right to equality is guaranteed, it is high time for the central government to look into the matter and, if required, to amend the provisions of Hindu Succession Act, by which the Hindu Succession Act is not made applicable to the members of the Children tribe. Not only this matter, there is one more judgment of 2025 SCC online, SC, page 1465, my lord. Para, last but one paragraph, para 28.
Name of the party.
Name of the party is Ramcharan versus Sukhram. And last but one paragraph, para 28.
Yes.
Granted that no such custom of female succession could be established by the appellant plaintiff, but nonetheless, it is also equally true that a custom to the contrary also could not be shown in the slightest, much less proved. That being the case, denying so-and-so her share in her father's property when the custom is silent would violate her right to equality vis-a-vis her brothers or those of her legal heirs vis-a-vis their cousins. And in this case, my father doesn't have any male share, so my father's male share will be taken by some other person. This is the problem, my lord. Can it be done, my lord? And as far as the finding of the honorable single judge is concerned, if your lordships kindly permit me, I'll just point out what is the finding. Just one paragraph, my lord.
Yes.
On page 208, my lord. 208, para 20, my lord. Insofar as entitlement of the petitioners for the communal land of village MU is concerned, it is difficult for this court to conclusively determine whether the petitioners, having married and settled in different villages with their respective spouses and families, would be entitled to compensation for the acquired community land. Second sentence is important. While it cannot be said that the daughters or family members of the village are per se not entitled to land compensation, the matter of the distribution of community compensation has been stated to be regulated by the decision of the village elders and the community itself, who have earmarked a share for daughters, sisters, and widows of Emily village. So this is, in my humble submission, is contrary to the Supreme Court judgment and section 30, my lord, which says if there is any dispute about apportionment, it has to be sent to the civil court. And then this second paragraph, my lord, para 23 on the right hand side, my lord. Having considered that the petitioners did not approach the authorities at the appropriate stage when claims and objections were required to be submitted under the relevant land acquisition law, this court is of the view that it would be difficult to grant any relief to the petitioners in the present proceeding. The petitioner, therefore, having failed to make out a case, etc., etc. No interface. My lord, Land Acquisition Act says if I am not there, by post it will be sent. Notice, my lord. So that being the position, my lord, these two paragraphs, two findings are contrary to section 30 and section 11 of the Land Acquisition Act, because if I do not raise any objection, even then I cannot be denied. Provision is very clear.
Government advocate.
So this maybe should be allowed.
It's an appeal.
Yes, sure. But I have the instructions, Your Lordship, that the remaining balance has been disbursed on 29th of August.
My lord,
Balance
you-
disbursed.
Yes, not this one.
Not yet disbursed, my lordship will direct the
The
deputy commissioner
office
not
of
to
the-
disburse.
Respondent number 3, I have been started.
Disbursed or not disbursed?
Disbursed.
The government advocate says it is disbursed.
My lord, it cannot be disbursed. Deputy commissioner cannot hurriedly do it, my lord. We have informed that we have filed an appeal. Your lordship will kindly direct the deputy commissioner not to disburse, my lord. And our instruction is, my lord, deputy commissioner should not be in a hurry when the other day the single judge disposed of the petition.
Disposed of in August 25. Yes. Deputy commissioner has disbursed the amount.
Yes,
Not yet, as per my instruction.
We have, my lord, our appellants have personally met the deputy commissioner and informed him that we have filed an appeal. Kindly do not disburse.
Mr. B. Assisted by Mr.
It is a regular post. Place of business. That it will change your business. So that will change your work.
The judgment and order dated 22/8. Whereby claims for compensation, equal compensation raised by the appellants, respect of land belonging to their father, which were required by the state, have been turned down. Yep. That the single judge, has delivered the judgment is contrary to provisions of the Land Act 1994, under which the land belonging to the father, along with other similar is required for public purpose. So, done at council. Yes, council, yeah. So, that when the question of the award of compensation was an issue before the deputy commissioner, the matter was referred in respect of the claims made by the appellant. Matter was referred to be decided by the village council or committee.
Village authority.
Society.
Village authority. And the decision was taken by the village authority that for all
My lord, actually, the decision was taken by the, my lord, society, one society, not a village authority.
by
Respond number
By-
8. Respond number 8.
by the respondent number 8,
My lord.
that in respect of the claim for compensation for the daughters, the widows, the amount of compensation to be paid them would be 20%, as opposed to the compensation which will be available for male here or the landowner. So the learned senior counsel submits that the appellant's father did not have a baby, and both the daughters, who are the appellant, both are entitled to be given the share of compensation than acquired, which belongs to their father. So, referring from Section 11 of Land Acquisition Act 1894, Mr. Mazumdar submits that the inquiry be initiated, inquiry and the award be issued by the collector are to be initiated in terms of the procedure prescribed under the same section. So, referring to section 11(1), sorry, 11(1), the
11(1), 11(1), Roman 3, madam.
11(1), Roman 3 submits that
Even
the
if-
apportionment compensation amongst all the people known or believed to be interested in the land are required to be apportioned, whether or
Even if-
not they have respectively appeared before him.
Absolutely, madam.
Therefore submits that even if the appellants not physically appear before him, considering the fact that they are the legal heirs of the landowner, they are entitled to full compensation as it's what to be granted to a landowner. So that brings to section 30,
My lord.
say that the senior accountant submits that in the event there was a dispute respect of portion of the section,
My
that the matter of have been referred the decision of the court and
Here it was referred to in society, my lord.
was incumbent on the collector
Refer to this.
in the
Oh,
event
your letter is 49.
apportionment of the compensation will be decided. Matter of who have been referred to. However, contrary to section 30, the Act, the matter referred in village society, namely respondent number
8.
8. So, society in turn had taken the decision that only 20%
20%.
compensation will be
For
apportioned
for all the females.
for all the female members of the society, including that of the appellants. So, the council for the petition has 45 is commission by placing the lines of the judgment of the apex court rendered in Kamala DT, reported in so and so. Wherein the senior counsel submits that in a matter before the apex court regarding the claim of equal share by
A female tribal.
by the female members of the tribal community, the apex court had held that there would be no justification to deny the right of survivorship so far as the female member of the tribal community is concerned. Where the daughter belonging to a non-tribal community is entitled to equal share in the property of the father, there is no reason to deny such right to the daughter of the tribal community. A female tribal is entitled parity with the male tribal interstate society, interstate succession. So, to deny the equal right, the daughter belonging to tribal community, even after a period of 70 years of the Constitution, under which the right of equality is guaranteed, it's high time to set up the matter. And if required, amend the provisions of the Succession Act. So, the council further refers to another recent judgment of the apex court under the Ramchar quoted in so and so. Support these contentions that denial of the female heir a right in the property only exacerbates gender division discrimination which the law should ensure without so. The Internal Senior Council therefore submits that the new judgment passed by the Internal Senior Council needs to be prepared and set aside. Watch and appropriate orders be directed towards the collector to ensure that proper and equal share of compensation is awarded to the applicants. General Government Advocate representing respondents. There is a decision by the respondent number 8, the community society. The apportionment has already been released. According to the Government Advocate, the compensation amount has already been released.
Yes, Your Worship, our objection to the repetition was there was no claim in objection. from the petitioner side during the entire proceeding. That is, that
It
was
was further submitted that during the entire proceeding, there was no objection raised by the appellant before the complaint. The per contra, Mr. Mudakar, for instruction submits that the amount of compensation has not been fixed. The heard counsel will follow the papers available. That this matter will require consideration and review objects of that recognition act 1894, read with the mandate, read with the judgment rendered by the apex court. It appears that these aspects prima facie were not taken into consideration by the judge that by rendering judgment under the particular. Let the appeal be admitted. Mr. Ira represents
1, 2, and 3.
1, 2, 3. The appellant will ensure service of notice on respondent 8 by registered proceeding along with the course. Custody is also permitted. It will be
My lord.
raised. Give us a date. Interim orders done about.
My lord, I'll just pray that at this stage, Lordship will direct the Deputy Commissioner as well as respondent number 8 not to disburse our amount of compensation as was directed earlier.
We are issuing a notice on a rental prayer. We want to fix a date. Let it be listed on end of September sometime, 22nd, 23rd,
My lord,
24th of September.
let it be 24th, my lord, yes.
24th of September.
My lord.
Meanwhile, the Deputy Commissioner, Anini, Dibang Valley District, will ensure that the compensation amount
Your Lordship, it has already been disbursed yours as per my instruction.
if not disbursed,
My lord? Yes.
that not be released.
Yes.
My lord, similar direction to be issued to respondent number 8 also. Society also should retain it because if society is now, if at all, released to society. Otherwise, once it goes, my lord, there will be no way out to recover that amount, my lord.
Should not be released.
Even if it is released, it is lying with the respondent number 8, my lord. My instruction is it has not been released. Your lordship will direct the Deputy Commissioner as well as respondent number 8.
Even the amount has already been released by the Deputy Commissioner, the society. Then the society, they will respondent number 8 shall not disperse the amount.
Belonging to the appellants, belonging to the appellants.
Belonging to the appellant shall not disperse.
Absolutely. Deeply obliged.
Apply.
Item number
Extra
7.
copies be furnished by the advocate on report.
Apply.
Item number 7.
Some affidavit.
I have the oral submissions summarized in my humble submission. Everything is on record. Our objection in the IA was already named.
Yes.
If Lordship, they are not filing affidavit in this matter, let this matter be fixed for the hearing because the arguing counsel is from Meghalaya, Mr. P. Yomi. So Your Honor may kindly fix the date for the hearing in this matter.
Yes. On the request made by the council for the information can be listed for admission hearing. For hearing or admission?
Admission.
For admission hearing. After 1 week,
Up to 2 weeks, Your Lordship.
after
It is convenient for fixing a date, Your Lordship.
give a date, tell us. 23rd of September, 23rd. 23rd of September.
Keep obliged.
Item
21, my lord.
21.
My lord, I'm for the private respondent number 6.
Who's for the petitioner?
My lord,
Have you informed?
yes, my lord. Actually, my lord, the learned counsel for the petitioner is undergoing medical treatment.
Item 21 stands adjourned on the request made on behalf of the council for the petitioner that is under medical. His petitioner counsel is indisposed. Matter stands deferred to be visited after 3 weeks. Yes.
May I please, my lord? I
Yeah.
beg to mention item number 22, my lord. I am for the respondent number 3. My lord, we want to bring on record the construction status of the project. So I request you, my lord, if you may kindly grant me 2 weeks' time to file additional affidavit, my lords.
Who's for the petitioner here? Have you informed the petitioner?
Yes, we have informed the petition, my
petitioner.
lord.
Yes, any objections? Right. Counsel for the, what is your respondent?
Respondent number
respondent?
3, respondent number 3, lordship.
Respondent 3. Counsel for respondent 3. Prays for 3 weeks' time. Place the status report.
Yes, status report of the construction of the projects.
Status report of the construction of the project by way of an affidavit. Prayer made is not objected to by the council for the petitioner. List accordingly after 3 weeks.
Highly obliged, my lord.
Item 7. Request made by the council for the petitioner stand deferred.
Please, my lord, I beg to mention item number 18.
18. Yes.
I'm for the petitioner, my lord.
18. You want an adjournment?
Yes, my lord.
Right. Item 18. The request made by the council stand adjourned. Instead after 2 weeks.
After 2 weeks, my lord.
Yes.
Item number 1.
Yes.
Yes, I'm informed, my lord, appellate authority, my lord. This writ petition is against my lord disciplinary order, my lord. I'm informed, my lord, appellate
I pass the order.
order, my lord.
Ah.
Therefore, my lord, I will pray, my lord, copy of the appellate order, and this case may be closed, my lord, with liberty, my lord.
So give him a copy of the order.
My lord, I'm sorry, but I had only one copy, but that I have given to your lordship, my lord. Can I take it back and I get the Xerox and so that I can?
We'll get it Xerox for you.
My lord.
It is submitted by the council, the bar, that the appeal preferred by the petitioner before the appellate authority stood dismissed by order dated 24th of July 2025. The order is placed before the court by the respondents. So, copy is also shared with the council for the petitioner. Give a copy. That view of the matter, the no further cause is alive with the writ petition. The writ petition therefore stands closed with liberty. All right, interim order, the penny stands vacant. Okay.
Item number 2.
Yes. The affidavit was to be filed. As filed. Let him file it.
Have filed this morning.
This morning.
Oh. Well, just I had a glance of it. The first, well,
We are yet to have a glance.
just filed it this morning, so it may not be available.
It is submitted by the Senior Standing Council, APPSC, that the affidavit permitted to be filed by the court by the last order has been filed this morning. And a copy thereof has been served on the council. We want to file the rejoinder.
But I thought of without going through also. on merit, I want to get this matter disposed of today itself, because in any case, going by their affidavit, the first thing that I understood in this matter is that, number one, this court by last order has categorically stated, directed that you have to file a video footage since you are conducting a civil service examinations. So these particular point has not been answered in their affidavit. Now, number two, my lord, other day they have played a video clip which was recorded from a mobile handset of a third party. Now, that was also not whispered even. In the affidavit, nothing has been brought on record. Now, number three, my lord, in that particular video, my lord, three boys whom they have shown, I was not there. My lord has also seen, the court has seen, everybody has seen. So,
Which may lead to two eventualities.
eventualities.
Number one, that you were already there in the campus.
Already there in the campus.
Or number two, you were not there in the campus, you subsequently managed to be in the campus.
No, my lord.
You are not there. We agree you are not there in the video footage. So, your case is that you were there in the queue. And they say that you were not there in the queue.
Correct.
You had managed to scale over the wall, etc., all these.
That's why, my lord, other day.
So, how does the court decide this issue
Now,
in the absence of evidence?
that's why, my lord, it is a serious question for consideration by this honorable court on the part of administrative laxity or failure. You are conducting such a civil service examination, and in examination center, my lord, you don't fix a CCTV camera.
Is there a mandate by any statutory or administrative?
They are in their rules.
What rules?
They are supposed to bring it on their examination rules that wherever they are conducting examination, it should be under proper surveillance. Now, my lord will kindly see, had it been a case that I have not entered into the compound,
That's what we are trying to tell you. If it was their case that you were not there in time, but it is only you after you were ushered in, you went there, and therefore by the time you reached the examination center, there was a delay. And your picture is available in the video. This is not the case. Your claim is that you were there well within the time.
well within them.
Their claim is that if you were there well within time, your biometry shows the timing at the time you got the biometric. You have to give an explanation as to why the biometry could not be undertaken prior to that.
My lord will appreciate.
Your explanation is that there was a queue. Now the question is, the second examination starts at what time?
1 p.m.
1 p.m.
And we were already inside the biometrics place before 12:40. And then, my lord, my instruction, my lord.
Perhaps the only way to, are mobile phones allowed there? No,
No mobile phone.
no mobile phones.
Then the pen and pencil is provided inside, not from outside.
So what is your proposal? How to go about it?
That way, Lordship, that. Let them file the reply. Otherwise, we'll say if there is no reply, we'll say that they have accepted our affidavit. Or else, if it is disputed, then let there be a civil suit. That is,
My lord, the affidavit on a plain reading by itself has not filed in compliance with the directive of this honorable court.
We have no copy of the affidavit as yet. They filed it today.
Well, because
So we are concerned about your
well, anyway, my respectful submission would be, let some law be laid down in such kind of
how
circumstances.
can a law be laid down without hearing the proper merits of the case? First, you will have to, the law cannot be laid in thin air. The facts must be properly laid.
I got that.
There is a basic, there is a, the foundational facts are in dispute. You say one thing, they say another thing. Now, who is to decide? It's a matter of evidence. We can give you liberty to go and file a civil suit.
No, but that will be there in any case, my lord. In any case, because what they have come out with a statement of those police personnel and 3 police personnel, they have said we were performing the duty inside the examination hall and we did not see anyone scaling up the wall. And my lord, that video footage which
No, see, it is like this. Let us go by your submissions. You were well within the campus before 1 o'clock. Right?
correct.
They are not supposed to drag you to the biometry, get it done before 1 o'clock. You have to explain that even if you were in the campus prior to 1 o'clock, why did it take you to get the biometry done at 1 past second of 3 minutes?
That the instruction, according to my instruction from the client, they say that they were in the queue since 12:15. And then what had happened?
By the time his turn came, it was
it was 12 it was over 12:45. Then what had happened, my lord? The authorities in the biometric center, they enter into an argument with these aspirants, including my client. And then because of that, it took more than 15 minutes time to pass test the biometrics. Otherwise, they have given those calculated clearance and all those things they have done. But it is prophesied.
so you file a reply. This will require some examination because some records here and there we'll have to make an attempt to see. But you think only question is that you know the
No, but what
ordinarily a writ court will not go.
no, but what Apan sir is trying to hit me is that this has become a question of fact. So therefore, under the MPW 26, the Writ court cannot proceed to decide the disputed question of fact. Very well taken care of, my lord.
So that hit is not only directed to you, it is directed to us also.
Everyone.
Because that is what he is saying, that it's a disputed question of fact. Writ court should not go, and he's correct about it. Therefore, we are asking you, how do you want to resolve these foundational facts?
I have to dispute there.
You have to find out.
No, that's fine, no, I'll do it. Kindly list on Tuesday. I'll share my rejoinder to them.
All right.
And I'll fix for disposal below.
Is permitted by this court on by the earlier dates, by the last dates, the Static Council in the PSC has filed the affidavit today morning, and a copy thereof has been served on the response of the council commissioner. So, council commissioner submits that we'd like to file a rejoinder. We'd like to complete his instructions and file rejoinder if so advised. Submits that the matter being urgent, be listed for admission hearing. Admission or it's for motion hearing.
But for motion hearing is notice has to be issued formally.
You want a notice to be issued
Formally. That's otherwise it cannot come to the admission.
need not be, it can be disposed of in the motion hearing.
Fine, whatever DP can probably.
If we issue a notice, then whether it will be proper to make it returnable by Tuesday, that's
Well, let it be
how many persons are there? Only public service commission.
only public service.
Then we'll make it returnable after 1 week or so.
My lord, can you keep it on motion? All right, fine.
Be listed for motion. An attempt may be made by the courts, dispose of the matter at the motion stage, considering the urgency expressed by the petition. Based on Tuesday.
In the meantime, I shall find my rejoinder.
Can it be on,
Even you liberty.
can it be on Wednesday?
Fine.
Wednesday.
10th.
10th. Based on 10th. Right.
Item number 3.
My lord, the instruction was called for in this matter because like I was selected, I was communicated for the post of accountant, and thereafter, without cancelling it, my lord,
The Sainik
Yes.
School.
Sainik School and fresh advertisement was issued.
Yes. What are the instructions, madam? That post and along with other posts has already lapsed, madam. As per the Sainik School's guideline, madam, it has to be filled up within a period of 1 year, madam. And the advertisement it was issued on 19 August 2019. And now what has happened to the new advertisement? New is as per the newly sanctioned post, madam. This is newly created post. So it was different. It is different, madam. There is only one post. That one post. Where is the earlier advertisement? Advertisement was issued on 19 August 2019, madam.
Page 23, madam.
23. And this has to be filled up within a period of not only the one post, madam. Altogether, madam, the post advertisement has to be filled up. Accountant, there is one post, madam.
Correct.
Now, subsequently, where is the subsequent advertisement? 18.
27/7, 2025.
It is also,
Page
madam,
46.
one post, madam. How many accountants do you have?
Only one.
Madam, as per advertisement, only one post has been advertised. So you said newly created post. Madam, it has to be newly created, madam. It has to be filled up as per the newly sanctioned, madam. That earlier that was, madam, lapsed due to, madam, the nationwide lockdown. The board proceeding was not done, madam. Madam, what happened in this case? The after advertisement, madam, the interview was conducted and some were selected, madam. And board proceeding was not done due to which, madam, the post become lapses, madam. And as per the guideline, it has to be completed within a period of 1 year, madam. But that has not been completed, and altogether, it is to be completed by which the period within which it has to be appointed is where is it mentioned? Nothing, madam. It is in the post advertisement, madam. It is not mentioned.
In the advertisement, madam,
But
nothing.
there is a madam, one letter, the guidelines issued by the madam, the ministry. Where is the guideline? Madam, of course, it is not there. They have not annexed, madam. It is bring it on record.
Madam,
We'll file affidavit, madam.
in the meantime, madam, only in respect of this accountant post, the
No, madam. This is a completely, madam, different
kindly
section.
Bring it on record, we'll consider it.
Yes, madam.
If there is a guideline to say that everything has to be completed within 1 week,
Yes, one year, madam.
then it's a different issue. But the school has given an email congratulating him that he was selected.
Even that is after expiry of madam, the appointment period, madam.
Whatever it may be.
It was communicated on 28th
page 30,
October, madam.
Right.
page 30, madam.
28th October 2020, madam.
Right.
Much after the expiry of madam, the appointment period.
But you have not brought that guideline or anything on record.
Yes, madam. Madam, due to short period, madam, we,
Bring it on record.
yes, madam, we file everything.
Third, counsel for parties. The pursuant to the earlier order passed by the court, done at DSGI on instruction submits that although in response to the first advertisement issued by the Sainik School, Siang, by advertisement dated 19 August 2019, the petitioner had applied for and was stated to have been selected for the post of accountant. But however, because of the nationwide lockdown COVID-19 situation, the further steps with respect of the said advertisement
same selection process conducted could not be completed. So submitted that there is a ministry guideline which makes it imperative that all selection proceedings, the selection process pursuant to advertisement, respect of Sainik School are to be completed within a period of 1 year. As the selection could not be conducted within 1 year, subsequently, by way of the next advertisement, dated, where is it? Subsequent advertisement
Is 46, 27/7,
dated 27/7/2025. Several other posts have been advertised, including that of the accountant. So the learned DSGI, however, clearly submits that the instructions are not available. The ministry guidelines not available with him at this moment. He will complete his instructions on that and bring it on record by way of an affidavit. So, considering the submissions made, that notice has been issued here. No, that notice issued, returnable 3 weeks. Mr. M. Kapo, the DSGI, represents all the respondents. Therefore, notices are waived, however, extra copies be furnished within a period of 1 week. The respondents may complete, the learned DSGI may complete with instructions and file necessary affidavit. There until the next date fixed, the selection process in the Sainik School is young, Ninglong village, Arunachal Pradesh. In terms of the advertisement dated so and so. What is the date of the advertisement? 27/7/2025. Insofar as it relates to the post of accountant within bracket regular, shall remain same. Subject to such further orders as will be passed by the court subsequently.
but only in respect of the accountant. Only on.
Item number 4.
Yes, what instructions? Why have you not released the person?
My lord, as per instruction, my lord, that one, my lord, the transfer order serial number 3, my lord, 11, page 11, my lord. My lord, he has submitted the application before the authority, citing his her medical ground, my lord. In this regard, the authority, they have constituted the medical board, my lord. Because of medical board report, my lord, further decision is awaited, my lord.
No, but then this order has to be stayed.
Yes, my lord.
Have you stayed it?
No, my lord, that is not there, man. That is why although it's there, my lord, the order is enforced, my lord.
The
Transfer order is there, my lord, and that is to be implemented, my lord, in my respectful understanding. Although there's personal problems
tomorrow, he may be hauled up to say that he did not comply with his order.
my lord,
Proceedings may be drawn up against him.
my lord,
His salary is stopped.
my lord is many.
Heard counsel for parties in deference to the earlier order dated 9/25. Learned Standing Council, Education Department. Instruction submits that so far as the transfer order dated 2nd of June 2025 is concerned, whereby petitioner was transferred from GHSS Bazar Line Sepa, its coming district, to GHSS Loipuma, Papumpare district. And he was to be relieved by the person mentioned in serial number 3. So, however, the petitioner could not be released as the person in serial number 3 has filed application to the higher authority for retention of a transfer on medical ground. And the higher authority has constituted a medical board for genuine cases. The final results are awaited. Where under such circumstances, this court is of the view that the order of transfer has not been recalled or modified by the competent authority. As on date, the petitioner has been transferred from present place of posting. The post which has been referred to with the transfer order dated 2nd of June 2025 topic is further submitted that the petitioner's salary in her present place of posting has been stopped in view of the fact that she has already been released by this principal. This court is of the view that the petitioner should be allowed to join in a new place of posting. So the respondent number 2 is directed release order, petitioner number 2, enabling her to join in a new place of posting. Stop this release order, however, will be subject to further orders as may be passed by this court. The respondents will thereafter take necessary steps for replacement of the petitioner in her school or present in the school where she was presently posted by making such alternative arrangements as they fitted proper. So, that notice be issued. The standing counsel, the standing counsel accepts notes on the applicant. Therefore, the way extra copies will furnished within 1 week. Matter be listed thereafter after the returnable date. Thank you.
Item number 5.
May I please have a
Yes.
better pertaining to ex gratia compensation for those of my husband, Martyr to the authority.
But this compensation has come in 2017. Your husband expired in 92.
Why not? But
How
there are
do you,
so many notifications. So many notifications are there. So the latest notification of this moment doesn't cover. But at the time of incident,
you are claiming compensation under which notification? 2017.
2017 notification.
So this 2017 notification will be effective from the date it has occurred. How do you want to get a prospective benefit, retrospective benefit?
My lord, that retrospective benefit apart from this, I'm entitled to get lump sum ex gratia as per the some principle, settled principle and some notification. I have submitted.
Which notification?
Ex gratia notification. My affidavit in opposition, my lord.
Huh?
Affidavit in repayment. I have filed affidavit.
Which notification?
Basically for my this is special benefit in case of death and disability in service, payment of ex gratia lump sum, compensation of
Page number?
families of
Page number?
page number 64 by
64.
existing.
of the writ petition.
Yes, yes. Continue to read it.
64, there is no page number 64 in the writ petition.
Read petition.
You are referring to which pleading, petition or affidavit?
Affidavit in reply, my lord.
In reply.
Yeah.
Right. Affidavit in reply.
My lord. Annexure A, my lord.
Annexure A. Recommendation by the district level. Is this a recommendation at the district level?
Sorry, my lord. Apart from this, I have filed one additional affidavit for bringing the records. Yeah, additional affidavit.
Yes, additional affidavit.
Yes,
Annexure A.
next, sir.
Yes.
Subject special benefit in case of death and disability in service, payment of a special lump sum compensation to families of the defense services personnel who die in harass, recommendation of the fifth Central Pay Commission. So according to this commission, that is HC minor, death occurring during enemy action in international war or border skirmishes and action against militant terrorist extremism. So my husband sought death in the Khalistani terrorist Operation Rocksup. He was deployed as one of the commando of the Operation Rocksup by the commandant. That's why he confronted the Khalistani.
When did he expire?
He expired on 16 June 1990. Why not?
It is again in 98. This notification is in 98.
Again, NXRB is there, my lord.
But these are all the primary notification is in 98. The incident occurred in 92.
May rely on a settled principle, my lord. That is, Guwahati High Court, the principle is there, and courts, settled principles are available. My lord. In Guwahati High Court, Guwahati High Court, Momi Saikia versus State of Assam case, the victim was shot dead by police personnel in the year 1981. But still, the Honorable High Court has received award 5 lakh them.
So it is not a case that you have not been granted any ex gratia.
No, not a single. I have granted.
Then
But the state government keep on assuring me anytime, they will create one monument on my dead husband and they will provide me extra. For maybe when they are really not providing me any compensation. Yes, this is a minor. Not compensation one time. My husband was Martyr soldier who has been awarded even 2 years of providing President of India.
Yes.
Similar matter, my husband's case. So here, page 5, paragraph 17 and 18, my lord. In view of the death of the appellant, due cardiac failure in the appellant is not entitled to leverage the family pension. So the payment of anesthesia amount compensation is concerned. We are convinced that the appellant is entitled to rupees 5 lakhs as anesthesia compensation in accordance with the infrastructure instruction dated 22/9/1990.
Oh, this is disability. This is disability pension.
The-
This is disability pension.
But he was the commanding officer.
No,
He
no.
died
Sir,
in Jammu and Kashmir.
no, no, kindly come to paragraph, page number 2, para 1. Pensionary benefits upon death or disability. Then come to para number 2. The liberalized family pension. In your case, you are asking for ex gratia, not for pension.
Here is in this case also why the High Court rejected, but the Supreme Court directed.
No, this is by for family pension. Is there no policy under the state? He appears to be declared as a martyr, given some gallantry awards.
State government has now come with the affidavit or notification, press notification, by which the payment will be paid. Now, the state government, I think, is paying. It's such a
Yes, Mr. Ram. We know that it is 2017, but considering the services rendered, I think it deserves a special consideration by the state.
My lord, you are the town of Koyana.
It is his misfortune that there was no scheme. But there is no dispute that he rendered his service. He is declared a martyr. He is awarded gallantries, given gallantry awards by the president. Under these circumstances, I think state should consider these issues, and peculiar circumstances, you should revisit your decisions. Where is your additional AG? Mr. Ratan? Please inform Mr. Ratan. We'll take it up after when. Wait for the additional AG to come. Oh. Thank you. He's here. Yes, Mr. Ratan, this petitioner before the court is a widow of an army officer. He was deputed for duty in Punjab. And during the course of his duty, he succumbed to, he suffered the line of duty. He is a citizen, he is a resident of this state. He is declared a martyr. He has been conferred gallantry awards by the president. The only thing is that at the relevant point in time, the state perhaps did not have any notification. So, technically speaking, yes, cannot claim for her ex gratia in 2017. But considering the services rendered, I think state government should take a special consideration. You examine this matter and you see if there is a way the services can be at least, the legal heirs are compensated for the services rendered. There is no dispute that he has rendered the service and he is a son of the soil. He is nominated for gallantry awards. So examine this matter and see if there is a decision can be taken by the state. We are not issuing any direction. We are only making a request. We can see if something can be done. Let them come back after examining this matter. We'll defer it for 4 weeks.
Even disaster management also provide. But here in my case, it's not directly sacrificing them.
The disaster management is on a different parameter.
Different parameters. Right.
Let him examine.
My right to life is my own.
Let him examine the matter.
Yes, yes. My lord.
The council. You are Mr.
You take
You take the council chairman. And Mr. Thakur, the ESGI. 3 and 5 for respondents, 3 and 5. Mr. Y. Ram appearing for the state respondents. The petitioner is the legal heir and the widow of late. What is his name?
Agoi Wangsa. That Agoi
Aboy.
Agoi AGOI. Agoi Wangsa.
Late Agoi Wangsa, who was a resident of the district of Longding in the state of Arunachal Pradesh. He was a sepoy or a Jawan of the Assam Regiment Army. And during an operation undertaken while on duty in the state of Punjab and Haryana, in the state of Punjab, he suffered fatal injuries in his line of duty and ultimately succumbed to the injuries suffered. So, the petitioner is the widow. The deceased soldier is survived by the petitioner, his old ailing mother, and 3 school-going minor children. So, the incident took place in the year on 16th of June 1992. So, the petitioner's late husband was declared as a martyr, and Surya Chakra within quotes was conferred on him posthumous, was awarded on him posthumous. The government at the relevant point in time paid a lump sum of 1,50,000 as group insurance towards the petitioner. So, the widow of the petitioner is currently receiving family pension. You're receiving?
Yes.
Receiving family pension. And the petitioner is agreed that in spite of several representations by the authorities concerned for grant of ex gratia payment in terms of the policies and the schemes by the government of Arunachal Pradesh, which was brought out under the notification dated 24/4/2017 for our case, has not been considered. There are other council for the petitioner submits that under the scheme of 2017, the categories, under the categories mentioned, in respect of injuries, in respect of, in cases of death while performing duties within the state or at the request of the state government, members of the armed forces, an amount of rupees 50 lakhs is paid as ex gratia. So, the case of the petitioner was placed before the district. Where is that recommendation of the district committee?
DC Longding, district committee.
Where is that? Of the writ petition. The district level board for the recommendation of ex gratia payment service personnel, where the deputy commissioner Longding was the chairman. The recommendation was made in favor of the writ petitioner for payment of ex gratia. However, same has not been considered by the state respondents. The respondents, both state and the union, have contested the case by filing their necessary affidavits. So, in their counter affidavits, both the state and the union have taken a stand that the incident happened in June 1992, well prior to the notifications published for grant of ex gratia. Therefore, the case of the petitioner cannot be considered better. The court having noticed the services rendered by a member of the armed forces happen to be a resident of the district of Longling in the state of Arunachal Pradesh, and the Yalutri Award conferred, and the status of Martyr being conferred on the late husband of the petitioner. From a quoting of the view that the prayer of the petitioner can be considered by the state, keeping in view services rendered by the late husband of the petitioner, as also in view of the recommendation made by the district committee, recommending the grant of ex gratia payment. So, considering the facts involved in the matter, and also noticing the services rendered by the late husband of the petitioner, who was ultimately martyred line of duty, this court requested the presence of Mr. Dinong Ratan, additional agent, the request to obtain the required instructions if the decision in this regard can be taken by the appropriate department. Mr. Ratan, showed the court that like to obtain his instruction, the matter that prays for 4 weeks' time. Considering the prayer made, matter be listed after 4 weeks, enabling Mr. Ratan to obtain his instructions. Can you supply him a copy of the petition that evidence? The registry may make available copies of the pleadings on record if required by the learned edition. List again after 4 weeks. Okay.
Item number 6.
My lord, I am appealing for exponent number 2 to 5.
Yes. You are, this is payment of income tax.
Assessment of income tax, my lord. Assessment was done against the petitioner, my lord.
You are covered under 1026.
My lord.
Yes, Mr. Sakia.
Lordship, in this case, initially, my lord, the petitioner has claimed, my lord, he's claimed immunity, my lord. He has not filed return and, my lord, submit anything. Subsequently, my lord, pursuant to notice issued, my lord, he filed return and, my lord, submitted other documents also, my lord. However, my lord, the reply to the show cause notice, my lord, that was not reflected to be, my lord, considered in the, my lord, assessment order passed, my lord, on 30th of March, my lord, 2022, my lord.
So, but 1026, they are not required to file return.
No, my lord, that is, my lord, 1026, that has been, my lord, the income of the petitioner has been exempted, my lord, but they are claiming immunity, my lord. My lord, the income, my lord, that has to be, my lord, examine whether that income was accrued within the state of Arunachal Pradesh or not, my lord. It is, my lord, not a, my lord, blanket exemption. It is subject to certain conditions, lordship.
Is she a service holder?
No, my lord. The petitioner claimed to be, my lord, a businesswoman, my lord, and she has executed certain contracts, my lord. And in response to the SOCOS notice that was issued on, my lord, 26/3/2022, she submitted her reply on, my lord, 29th, lordship. And, my lord, in the order dated 30th March 2022, that has not been reflected to be considered. On the last occasion, lordship, on 7/4/2025, this honorable court has directed us to produce the relevant records in this respect, my lord. In fact, on the last date, I have also produced a scanned copy of the records as directed. But from the records, it's appeared that, my lord, that reply was not considered, my lord. It was, though it was on record, my lord.
Where is the reply?
My lord, in our in our, my lord, the records we have submitted, my lord, in page, my lord, 11, it was reflected, my lord.
You have furnished some records.
Lordship, scan copy of records, my lord. That is the order sheets of.
It's not a part of the affidavit.
It is not part of the
This,
affidavit.
is this the order sheet? Order sheet details.
Lordship.
Which page is it?
My lord, it was in, my lord, page 13, page 12, bottom, lordship, of our records, my lord, we have submitted. Page 12, bottom, 29/3/2022, response from SSC. On the next page, lordship, page 13, noting remarks. Copy of work order of Shimnit has been attached again as earlier. It was not scanned properly. So it was on record, my lord. In the assessment order, it was not considered.
We'll have to revisit it.
Lordship.
So is there a reference of this reply in the impute order? No.
No, my lord.
So it has to be revisited.
Lordship.
But what is the provision under 197 that the ITO has to issue a certificate that you are exempted? Is it still there? Certificate is there.
Certificate is there, my lord. That is annexed, my lord, by the writ petitioner, my lord. And that is also, my lord.
Page 51, my lord. 51. Yes.
Last para, my lord, that is also clearly state that on the income which accrues or arises to him, her, from any source in the area of Arunachal Pradesh. So we have to verify this, whether that income was accrued within the state or not.
Yes, you have information to show that it was not within the state. You have some inputs. What we are asking you, once you are exempted under 1026,
My lord.
Are you still required to file your returns?
Yes, lordship. Because, my lord, this certificate, my lord, that itself has said, my lord, in case of income accrued within the state of Arunachal Pradesh, that is only exempted, my lord. Otherwise, 1026, my lord, it's only an exemption, my lord, certain conditions, my lord. And whether that conditions were fulfilled or not, that has to be, my lord, determined, my lord, based on return, my lord. So, my lord, he filed the return, my lord, subsequently, my lord. So far as the other issues, my lord, that is, my lord, not disputed, my lord. But we want to see the, my lord, the sources of income, my lord. And therefore, my lord, notice was issued, my lord. And, my lord, apparently, my lord, yes, he filed his submissions, his reply, my lord. But somehow, my lord, it was not reflected in the, my lord, the assessment order, my lord. From the records, my lord.
So we'll have to interfere with the assessment order, remand it back for a fresh consideration.
Lordship, that will be the best course of action, my lord, probably.
Unless you want to say that you are not required to file return under 10. Listen, I have an extra documents here. Forget documents, you show us. If you want to urge on this, that you are not required to file returns because you are exempted under 1026. Income tax act.
My lord, section 139 says, my lord, every person has to file his, my lord, return, my lord, in case, my lord, his receipts, my lord, exceed certain amount, lordship. May I read, Lordship, section 139,
Yes, yes, just a minute.
Lordship.
Yes.
Lordship, section 139(1), every person, A, being a company or a firm, or B, being a person other than a company or a firm, if his total income of the total income of any other person in respect of which he is accessible under this act during the previous year exceeded the maximum amount which is not chargeable to income tax, shall on or before due date.
You are to file return over and above the amount which is not chargeable.
Lordship, Lordship.
So, because it is a self-assessment tax, so therefore you file returns declaring the income which is not exempted or which is beyond the exemptions under 1026.
My lord, my lord.
Ordinary.
Lordship.
Unless you have some information to say that this is not required to be, this is required to be filed.
Lordship, initially, my lord, notice was issued, my lord, under 148, Lordship, showing that, my lord, he has received, my lord, some huge amount in his, my lord, bank account, my lord. So that is the information, my lord.
Yes, what? You are not urging the case that.
I have taken the ground petition also, and I have not denied in the affidavit in opposition also.
What?
These documents are the income which I have accrued, not in the state of Arunachal Pradesh.
No, that's not it. It is not. You are not urging before the court that 1026 gives you an exemption, blanket exemption. Therefore, you are not called upon to file return because returns are cast upon the person who are required to pay income tax. This is not your case. Your case is that you have filed the document before the assessing officer, they did not take into account. All right. Third, counsel for parties. This writ petition is filed with the petitioner, putting to challenge the assessment order. Where is the new order?
Page 115.
Page
115, 115.
115. New order dated 3003/2022, passed by the assessing officer under the National Faceless Assessment Center, whereby assessments were completed under section 144 of the Income Tax Act 1961. On the ground that no response or reply was filed by the SSC to the notice issued. Stop. Accordingly, what is the total amount of demand?
Page 142, 3 crore 94 lakh.
394.
394.
394,69,944 was raised on the petition. So, although statutory appeal is available under the provisions of the Act, and ordinarily, the court is not required to exercise jurisdiction. The writ petition was filed, putting a challenge to this order on the ground that the reply or response in filed by the petitioner to the notice issued by the petitioner, by the respondent department, prior to the assessment order was already filed, and the assessment order was filed without referring to the response filed by the petitioner. So, during the pursuant to in deference to the orders passed by the court, the Learned Standing Counsel Income Tax Department was directed to produce a copy of the returns, copy of the order sheet case. So the same has been placed before the court, and from a perusal of the order sheet, it's found that on 29/3/2022, the response from the SSC, namely the writ petitioner, was already before the assessing officer, and that a part of the work order has also been attached as it was not scanned properly. So therefore, it appears that the response filed by the petitioner, the notice issued by the Income Tax Department prior to the assessment order, was already before the department. So, under such circumstances, it is fairly submitted by the others. You are the senior standing counsel?
Lordship, senior standing counsel.
Senior standing counsel in the Income Tax Department. That because of oversight, perhaps the response was not considered. Accordingly, this court is of the view that the writ petition should be allowed. The impugned order of assessment dated so and so, along with the demand raised, is hereby set aside. The matter is remanded back to the assessing authority to pass appropriate orders by placing reliance on the response received and filed by the petitioner. Response filed by the petitioner, received by the department. So, this order, the exercise of writ jurisdiction by this court is necessitated by the fact that the impugned order of assessment is passed contrary to the provisions of law without referring to the response filed by the SSC. So, therefore, the presence of alternative remedy is not considered to be a part of facts of the petition allowed. Disposed of interim orders if any stand marks pending eyes are also dismissed.
Kind indulgence. Well, item 8, but the instruction has not come as additional AG informed
For some of them,
after 2 weeks.
your mention time is already over.
I am extremely sorry. I have some difficulty to move outside.
We can exempt the president of the bar.
No, madam.
Item 8, joint request that deferred to be listed after.
Great.
Item number 9.
Please, Your Lordships. Your Lordships, day before yesterday, we had mentioned, Your Lordships, that this petition has been filed due to non-payment of statutory interest and due to non-processing of the refund application, Your Lordships, for the different assessment periods.
Yes.
Your Lordships had directed us to file a compilation to place on record the act and the rules and the judgments that we are relying upon, Your Lordship. That has been filed, Your Lordship. If Your Lordships may have the compilation.
Yes.
And if Your Lordships, if Your Lordships may permit, I'll show the relevant provisions of the Andhra Pradesh Goods Tax Act, Your Lordship.
Andhra Pradesh.
Arunachal Pradesh, I'm so sorry. Arunachal Pradesh,
Yeah.
I'm so sorry.
Yes.
Your Lordship may have page 138, Your Lordship. The relevant
138.
provisions relating to refunds.
Yes.
which is section 40.
Yes.
I may read, your lordships. Subject to the other provisions of this section and the rules, the commissioner shall refund to a person the amount of tax, penalty, and interest, if any, paid by such person in excess of the amount due from him. Before making any refund, the commissioner shall first apply such excess towards the recovery of any other amount due under this Act or under the Central Sales Tax Act 1956. Subject to subsection 4, any amount remaining after the application referred to in subsection 2 shall be at the election of the dealer, either refunded to the person within 1 month. Your Lordship, this is important. Within 1 month after the date on which the return was furnished or claim was made for the refund, or carried forward to the next tax period as a tax credit in that period. Now, your Lordships, in this case, subsection 2 does not apply because the commissioner did not apply to adjust it with any excess towards the recovery of any other amount. And we had made the refund application, we had made the refund claim application, your Lordships, on 7/10/2016, which was received by them on 14/10/2016. The last occasion, your Lordships, we had shown the application, my Lord. And therefore, within 1 month of that, the refund was due to be paid, your Lordships. Then your Lordships may have section
You have
44.
already got your refund. You have already received your
The
refund.
refund, we received it
You
on
are now
10th
before
March
the
23.
court for grant of interest.
Statutory
delayed payment.
interest. Yes, my lords, which is section 44, my lords. So that is for the assessment period 2013-14 and 14-15. For the subsequent assessment periods, they have again not processed my refund application for the subsequent periods. Already 3 years have lapsed since I had submitted my refund claim, your lordship. And in this case, for the 2013-14 and 14-15 period, there is a delay of 6.5 years, your lordship. Admittedly, my lords, this is an admitted fact. The refund application was received by them on 14th October 2016. We approached your lordships, this honorable court, and by an order dated 29/11/2021, your lordship had directed that the refund application may be processed expeditiously. Only thereafter, even after your lordship's order, 2 years after that, refund was issued, my lords, on 10th March 2023. Therefore, your lordships, one, I'm requesting that statutory interest as per section 44, your lordships, is at page 139 of the compilation. As per section 44, the statutory interest, as per the notified rate for the relevant times, they may compute it as per the notified rate from 14/10/2016 to 10th March 2023. And after 10th March 2023, your lordships, I'll show the relevant Supreme Court judgments, your lordship. We are also seeking a compensation should be paid for non-payment of the statutory interest, which has been granted in some cases, my lord. There are 2 judgments of the Honorable Supreme Court which I've handed to the court master today, my lords. The judgment in the compilation, my lords, which we have relied upon the Supreme Court judgment.
First, let us deal with the interest part.
Yes, my lords. Yes, my lords.
Yes.
And they have not denied it, my lords, in their counter at page 89.
This is interest after to be calculated. This interest is after the due date, is it? To be paid after the due date.
Yes, my lords. So if your lordships, this section 40A, which we just saw, my lordship, at page 138, clearly says the amount shall be refunded to the person within 1 month after the date on which the return was furnished or claim was made for the refund. So my claim was made on 7th October 2016. It is admitted that it was received on 14th October 2016. And the payment was made only on 10th March 2023, beyond the period of 1 month, your lordship. The due date was 14th November 2016. So it has to be computed from that date, my lords, 14th November 2016 to 10th March 2023.
Yes. Now, what is the judgment you are referring to?
Yes, my lords. My lords, the first judgment, my lords, in the compilation, And if your lordships may see, page this is Union of India versus Bill over your lordships 2022 9 SCC 341, and at page 200 and 2022 is the issue which was arising in this particular judgment, my lords. Page 222, para 5. Lordship has it. My lords, para 5. In both the petitions, it was submitted that inaction leading to inordinate delay in granting refunds was per se arbitrary, and that the inordinate delay impacted the working capacity of the writ petitioners, thereby reducing their ability to conduct business, and as such, appropriate compensation ought to be awarded along with interest for delay. And then your lordships may have lordship may have the finding, your lordships, is at page 243, your lordships. This was arising under the GST Act, my lords. Section 55 and 56.
Yes.
Which also provided for payment of statutory interest. Lordships may have page 243, para 21. It must also be noted here that the inordinate delay of up to 17 years in making refunds was a special circumstance when this court was persuaded to accept grant of interest at 9% in Sandvik Asia. Even while doing so, the observations made by this court in para 48 of the decision are quite clear that the award of interest and refund and amount must be as per the statutory provisions of law. And whenever a specific provision has been made under the statute, such provision has to govern the field. Then your lordships may have para 22, your lordship. Since the delay in the instant case was in the region of 94 to 290 days and not so inordinate as was the case in Sandvik Asia, the matter has to be seen purely in the light of the statutory provisions concerned. In terms of the principal part of Section 56 of the CGST Act, the interest would be awarded at 6%. The award of interest at 9% would be attracted only if the matter was covered by the proviso to Section 56. The High Court was in error in awarding interest at the rate exceeding 6%. In the instant matters. In the present case, your lordship, as per section 44, which is at page 139, the statutory interest payable is 6%, is between 6% to 12% as notified. Well, so therefore, my lords, I'm seeking a direction that they may calculate the interest within a stipulated period of time as per the notified rate. For the statute interest may be computed and paid to me at the earliest, your lordships. Because I'm a capital intensive industry, my lords.
And the affidavit, what is the stand of the respondent in the affidavit?
Yes, my lords. They have not denied this, my lords. If I may show you one paragraph, my lords, page 8. The counter, my lords, is at page 83.
Just one.
And at page 89, your lordships may have para 20. Lordships has para 20 at page 89. If I may read, your lordships, that with regards to the statement made in paragraph 26 of the writ petition, the answering respondent begs to state that the interest amount claimed is not correct. The application for refund was received on 9/4/2018, which is incorrect, my lords. I can show from the record, my lords. It was 14/10/2016. 9/4/2018 was a reminder. And the amount was paid on 10th March 23. And thus the delay in making payment was 1794 days. Because we are disputing the days also, because according to us, it should start from 14 November 2016. Further, the delay was not intentional, and the reason for the delay was already mentioned in paragraphs 8 and 10 of this affidavit in opposition. And as such, if interest has to be paid, then the rate of interest shall be calculated at 6%. Their reason is, my lords, lack of funds, etc. But they don't deny that there is a delay.
Para 8 and 9? What is that para 8 and 9? They have given the grounds for.
Yes, my lords. That is, and that in fact, my lords, has attained finality in this High Court's order, the grounds for making delay. If your lordships may have page 80.
No, let us come to para 8 and 9.
Para 8 and 9, my lords. That's at page 86. That with regards to the statement made in paragraph 12 of the writ petition, the answering respondent begs to state that the claim amount was readjusted by excluding the portion of inadmissible claims and an amount of rupees 1 crore 79 lakhs odd only was paid and not 1 crore 84. I have no dispute with that. The delay occurred as the department has to seek budgetary support from the government. Further, the delay was also due to COVID-19 as the normal work of the offices were affected owing to lockdown and other related issues. Therefore, the payment of interest may be waived off. Then, my lords, at para 10, that with regards to the statement made in paragraph 15 of the writ petition, the answering respondent begs to state that the delay in making payment was due to non-availability of fund. Because the application, the refund became due in 14th November 2016. There was no COVID, there's no, and the reason for lack of fund can't be a reason for unauthorizedly withholding the payment due to me, Your Lordship.
Where is the application for refund?
Yes, Your Lordship. That is, Your Lordship may have page 26. That is dated 7th October 2016, Your Lordship. The refund application is made in form 09, my lords, FF09. So if Your Lordship may have, with reference to the above subject, we are pleased to submit the yearly assessment report of tax and excise. Please find herewith attached assessment report for the year April 2010 to March 2015. Enclosed herewith form FF09 along with all relevant supporting document for submission and needful record, please. Then Your Lordship may have the next page, page 27. This is received on 14th October 2016. Because Rule 47 provides that the refund application has to be made under FF09. This is the application for refund. Your Lordship may have page 28, which is the refund application, page 28. Total tax refund claimed. Grounds for claiming refund. Page 29 is, yes.
29.
Page 29 is Your Lordship's order because my refund application was not processed and therefore
When was the refund allowed?
10th March 23, Your Lordship, and that Your Lordship will find page 32. I have produced the account statement, Your Lordship. My account statement. As to when the amount was credited. And if Your Lordship may have page 34. Lordship may have page 34, Your Lordship. And in the middle of that page, Your Lordship may have this payment of 10th March 2023 credit. Your Lordship has it?
178 something.
Yes, it was 1 crore 79. 1 crore, it's the branch code is numbered 6091. Then Your Lordship may find the credit is 1 crore 79 lakhs 52,614. It's the same amount as that refund application, which they have said that this is what was processed, madam. This is 10th March 23, the credit came, my lords.
That's all.
So,
Anything more you want to submit?
yes, my lords, this is with respect to the interest, my lords, statutory interest. Then, Your Lordships, there are two judgments which I've handed over today, my lords, to the courtmaster. Basically, my lords, that even compensation where there's an inordinate delay. Now, my lords, in this case, I leave it to the discretion of Your Lordship, my lords, but in this case, due to the inordinate delay, from 10th March 2023 till date, till the payment is made, my lords, Your Lordship may also consider granting compensation, my lords. It was not interest on interest. This Honorable Supreme Court in two judgments, my lords, may have. I've handed it. One is 2006 to SCC 508, my lords. Learned Courtmaster, I may request Courtmaster to hand
Yes,
over.
we have got it.
Yes, my lords.
Yes, yes.
Yes, my lords. Now, in this case, my lords, if your lordship may have Sandvik Asia, the issue is at page 9, my lords, the internal page 9, para 2. Para 2, your lordship. It says if I may read, my lords. The main issue raised in these appeals is whether an SSC is entitled to be compensated by the Income Tax Department for the delay in paying to the SSC amounts admittedly due to it. The delay in the instant case was for various periods ranging from 12 to 17 years. Now, my lords, if your lordship may have the finding, para 46, your lordships, which is internal page 40. Lordships has para 46, which holds assessees are to be compensated for withholding statutory interest. This is para 46, my lords. If I may read, my lords, the facts and the law referred to in paragraph would clearly go to show that the appellant was undisputably entitled to interest under section 214 and 244 of the Income Tax Act, my lords, here, as held by the various high courts and also of this court. In the instant case, the appellant's money has been unjustifiably withheld by the department for 17 years without any rhyme or reason. The interest was paid only at the instance and the intervention of this court in civil appeal so and so. Interest on delayed payment of refund was not paid to the appellant on 27 March 1981 and 30th April 1986 due to the erroneous view that had been taken by the officials of the respondents. Interest on refund was granted to the appellant after a substantial lapse of time, and hence it should be entitled to compensation for this period of delay. The High Court has failed to appreciate that while charging interest from the assessees, the department first adjusts the amount paid towards interest so that the principal amount of tax payable remains outstanding, and they are entitled to charge interest till the entire outstanding is paid. But when it comes to granting of interest on refund of taxes, the refunds are first adjusted towards the taxes and then the balance towards interest. Hence, as per the stand that the department takes, they are liable to pay interest only up to the date of refund of tax, while they take the benefit of assessees' funds by delaying the payment of interest on refunds without incurring any further liability to pay interest. This stand taken by the respondents is discriminatory in nature and thereby causing great prejudice to lakhs and lakhs of assessees. Because of this judgment, your lordship, the correctness of this judgment was taken up in another judgment, my lords, which is 2014 1 SEC 126, Commissioner of Income Tax versus Gujarat Fluorochemicals. And if your lordships may have para 1, my lords. Doubting the correctness or otherwise of the decision of this court in Sandvik Asia, a bench of 2 learned judges have referred the following question of law. Question of law is not question which arises in this case is whether interest is payable by the revenue to the assessee if the aggregate of installments of advance tax TDS paid exceeds the assessed tax. And then para 5 and 6, your lordship, the correctness was upheld and it was clarified, my lords. Para 5 and 6 are internal page 3, my lords. I may read, my lords. In our considered view, the aforesaid judgment has been misquoted and misinterpreted by the assessees and also by the revenue. They are of the view that in Sandvik case, this court had directed the revenue to pay interest on the statutory interest in case of delay in the payment. In other words, the interpretation placed is that the revenue is obliged to pay an interest on interest in the event of its failure to refund the interest payable within the statutory period. Para 6, my lords, as we have already noticed in Sandvik case, this court was considering the issue whether an assessee who is made to wait for refund of interest for decades, be compensated for the great prejudice caused to it due to the delay in its payment after the lapse of statutory period. In the facts of that case, this court had come to the conclusion that there was an inordinate delay on the part of the revenue in refunding certain amount, which included the statutory interest, and therefore directed the revenue to pay compensation for the same, not an interest on interest. This is my submission, my lords, on the payment of interest and compensation. And then, my lords, the second issue, my lords, was that I had made a refund application for the subsequent periods of, my lords, 2016-17 2015-16, 16-17, and 2017-18. Now that application, my lords, I had made, the assessment order, my lords, is at page 57, which, if your lordships may have, page 57. This is on the second issue, my lords, that my refund application is not being processed.
Fifty-seven is the notice of assessment.
Yes, my lords. This is for the year 2015-16. And if your lordship may have, total payable refund claim. Total payable refund claim, 1 crore 15 lakhs odd. This is for this year, my lords, 2015-16.
Yes.
And then, my lords, if lordship may have the next page, if your lordship may have 62, page 62. That is for 2016-17. They brought forward the tax credit of the past year, and therefore the total refund claim for both the years 2015-16, 16-17 was 2 crore 55 lakhs. If your lordships may have, total payable refund claim, page 62. That's for 2 years, my lords, 2 crore 55 lakhs. Then, my lords, for the third year 2017-18 is at page 67, the order of assessment.
How many refund claims are you making in this petition?
My lords,
For which year?
for all these 3 years, my lords, if you are on page 67, they consolidated, or the order was that for all the 3 years, the total refund claim was 2 crore 56. And therefore, I filed my form on 12th December 2022. The order of assessment was 9 December 2022, and page 69, your lordship may have. Page 69, I made a refund claim for all these 3 years, consolidated claim for all these 3 years, my lord.
59.
Page 69, 69.
So this is a consolidated claim for
2
15-16
Yes, my lord.
up to 17-18.
Yes, my lord. If your lordship may have the reference in that.
But your claim for refund is it not belated?
No, my lords, the assessment order was 9th December 2022 for these years, and my refund application is 12 December 2022. And they have not processed this for the last 3 years. They had to process it. And in fact, your lordship may have
What is the order of assessment?
9th December.
Date of assessment 9/12.
Yes, my lords, this is 9/12. 9/12/2022. Page
You
57.
filed your refund on
12/12. 2022. And after that, my lords, the superintendent of tax, he sanctions the refund and requests the commissioner to take the necessary action. That is at page 71. That's on 15/12/2022, my lords, page 71. It says, my lords, with reference to the subject cited above, which is the application for refund dated 12/12, I would like to state the following in regards to an application of refund claim. That, sir, as per the tax assessment proceedings completed for the period from April 2015 to June 2018, an amount of 2 crore 56 lakhs 76,000 only is found to be eligible for refund. Accordingly, a refund claim application is submitted by the concerned taxpayer by letter so and so. This is for your very kind information and necessary action, please, towards sanctioned release of the refund claim. Now, even after that, my lords, I had sent various representations and there has been no response, my lords. And the reason, my lords, I point out, my lords, the reason they have given in their counter is that this sanction is not by the government of Andhra Pradesh, Arunachal Pradesh, my lords. It's not by the government of Arunachal Pradesh. Even when, your lordship, in this letter of 15/12/2022, it's clearly written Government of Arunachal Pradesh, Office of the Superintendent Tax. This is the response in their counter, my lords, that the sanction is not by the government of Arunachal Pradesh. So, in fact, my lords, similarly, even for the past refund claim for the period 2013, 14, 14, 15, we had to approach your lordship, my lords, and then request, and your lordships had directed at process the refund claim, and only then the refund was processed after 6.5 years. Already, my lords, 3 years have passed. My request is, my lords, your direction may be given to process my refund application within a stipulated period of time, my lords. Because otherwise, again, my lords, there'll be a delay, and I'm a capital intensive industry, my lords. I set up power transmission lines. That will affect the cost increases, my lord. Then I'll have to borrow from the market my working capacity. That will have a cascading effect on the tariffs, etc., my lord. So this withholding of the money, my lords, is very detrimental to the business, my lords.
Yes. That's all.
Yes, my lord. Obliged.
Respondent. There is something. What's that, the other code? No refund they have got. No, there's some. Is there any refund to be paid now? Is there any refund that you're required to receive? For which years?
Yes, my lords. So for 2013-14, 14-15, I am required to be paid the statutory interest from 14-11-2016.
We're asking you regarding the refund. Refund entitlement, is there any refund receivable by you?
Yes, my lords, 2 crore 56 lakhs for the 3 assessment years. 2 crore 56 lakhs is the refund amount which I have to get.
But you mentioned that you had received the refunds.
My lords, that was for the different assessment period. There are 2 assessment periods, my lords. In my petition, there are 2 issues. One is for the assessment period 2013-14 and 14-15. For that, I have received the refund, my lords. I have received the refund on 10th March 2023 after a delay of 6.4 years.
There you are asking for an interest.
For statutory interest, your lordship. From 14 November 2016, when they received my refund, when 1 month had expired from the receipt of refund application, till 10th March 2023, when refund was made.
And what is the period for which you are still awaiting for your refunds?
That is the assessment period 2015-16, 16-17, and 17-18, your lordship. Yes, my lords. 2015-16, 2016-17, and 17-18. The assessment order was, your lordship, 9/12/2022, where refund was allowed. Your lordship, where I was entitled to refund. And 12/12/22 was my application for refund claim, which is still pending, my lords. And here the amount involved is, my lords, amount involved is 2 crore 56 lakhs 76,239. That is page 67. And my lord, section 44 will apply to this refund claim also.
Yes.
In fact, even though your lordships in the order dated 29 November 21 had clearly said you will process the refund claim keeping in account section 44, which is the interest clause, my lords, still the interest amount was not awarded, my lords, while or not paid while paying the refund, my lords.
Yes.
Please.
Regard to the refund period, when 16 to 17-18, as per our here, documents are sought for it's a single seat, my lord. And in between the new GST have come into effect. So for that, we first some time examine. That is place for our. With regard to the interest for the assessment year 2013-14 and 14-15, that interest portion, what the petitioners they are claiming is that they had applied for refund on that is 14th October 2026. Madam, it was received on 14th, as per page 27 of the petition. Page 27. This has been addressed to the superintendent of tax and excise, and this was received. My lord will see on 14th October 2016 by Inspector of Tax and Excise, Balukpung, my lord. Now, as per our affidavit, the main office, commissioner's office, did not get this. Rather, they got the application. Might have been the reminder. The application is not available. No, but the reminder when it was sent in 2018, then immediately it was processed, madam. Then page 93 of our affidavit, madam. Please to process the refund. The commissioner, madam, this application was made on 28/3/2018. Oh, this page number 27. Yes. Filed on which date? This is on filed on 7 October 2016. It's on the top, madam. But received on 14. This is the what is this? The receipt of this. In fact, what we are saying that this is 14/10/2018. 14/10/2016. 16. Yeah, that's it. So you are saying that this was never received? Yes, my lord. This was not forwarded by the Inspector of Tax and Excise, Malukung, to the commissioner. But is it a case that this was not forwarded in time, but subsequently it is available, or it is not available in the record? Not available as per our affidavit. We are saying that we received it on 28/3/2018 at page 93, madam, of our affidavit. And then we have processing. Page 93. Although they have referred to this earlier refund applications, madam, but this was on 28/3/2018, and this was received on 9 April 2018. I started the process on 9 April. So this is yes. So in our affidavit at page 86 also, we have clearly mentioned 86. Regards to the statement that we got, the refund application was received by this office in this office on 9/4/2018, and the same was processed on 18/4/2018. So please, so this is on 18/4/2018. Yes. So there is a dispute in the date of receipt of the application. But in any case, one of the hours then will be that
This is for the earlier part.
earlier.
What about the subsequent years of refund?
I have submitted that is under examination.
This is for which year? 2013, 14.
13, 14, the interest portion.
13, 14, 14, 15.
Yes. The refund amount has been calculated and paid, my lord. Now they are claiming interest on this. So the period of refund is disputed. As per them, it is in 2016. As per us, it is in 2018.
Yes.
So even though we pay the refund, we will calculate it from 2018. Date we have accepted that the application.
Do whatever you want to. You are not otherwise disputing their claims for refund and
Yes, madam.
interest. Even for interest, you are not disputing.
Interest also, only the date. Date is big.
Do it within the time frame.
Yes, madam. And that interest also, as per the madam, section 44. That interest also, since we have said that lack of fund and then in between the COVID period again. So interest also is to be paid between 6 to 12. Then we will go and we pay by the interest of 6.
And what about the compensation they're asking?
Well, since we have made our mistake, that was not deliberate.
Is there any appellate provision?
No matter in our state, there is no appellate provision for that.
All right. That's it.
May I make a submission, my lords? So far as the
Yes.
date is concerned, my lords, if your lordships may have page 93, which my learned friend was showing, that they did not receive the application on a prior date, my lords. Firstly, my lords, the letter has been endorsed by the inspector of tax. So it's an endorsed, signed acknowledgement on that letter. But I'll show that, my lords. But page 93 also, if your lordships may have the reference. It first mentions the reference 1 mentions our application dated 7th October 26, and thereafter item 2, your lordship, letter reference dated 5/12/2016 issued by Superintendent of Tax and Excise, addressed to the Commissioner Department for seeking approval of refund duly acknowledged by your office on 8/12/2016. Because this also they have not denied. This is a Superintendent Tax Excise, my lords. So the contention that this has been received first time on 28th of March 2018 is completely wrong, my lords. And page 27, my lords, there's an endorsement. How can they deny that, my lords? There's a signature.
The question question is with regard to the dates.
Yes.
So you're not
So we have, as per our affidavit, this reminder when it was received, then we have immediately started processing, my lord. And we are saying that we are not disputing this, the contents of this. What is that? It might not have reached. So immediately when it has reached, we have started processing it. Whether this has been received or not, it might not have been received by the commissioner's office, the forwarding and all.
Does the records show otherwise, my lords, and humbly submitting it?
Their reference.
yes.
So with regard to the period of interest, this will be calculated as per this our submission. And then at the rate of 6% interest.
Heard this one.
My lords, may I only request, my lords, that a stipulated time period may be directed to be given, my lords, for payment of the statutory interest and processing of the claim. My lords.
We'll consider that.
Obliged, my lords. Obliged.
Item number 10.
Please.
Lord, I appear for the caveat term. I'm on a caveat.
Yes, please. In fact, it came to our notice, that is why the matter got deferred on the last occasion, that there was a caveat on record. There's a caveat. There's a caveat. The PD data. Preparing for the caveat. Caveat discharge. Yes, please. This challenge is an interim order passed under section 9. But it's to confirm this facts and certain documents about your judgment. But a tender came out by the President of India through Ministry of Road Transport on 9th July 2020 for construction of a road of about 43 kilometers. An agreement is executed on the 9th October 2020 with certain relevant paragraphs of the Lordship may have. Page 88 is the RFP book. That's statement 206. That's where the agreement begins. EPC agreement. And your Lordship have page 1. Clause 4.2. Yes. This is an agreement between the and the appellant before Lordship. These are 4.21. The contractor, I am the contractor, whether joint venture or so, shall not subcontract any works more than 49% of the contract price and shall carry out works directly under its own supervision and through its own personnel and equipment at least 51% of the contract price. Further, in case the contractor is a joint venture, then the lead member shall carry out works directly through its own resources, men, material, and machinery in at least 51% of the total length of the project highway provided, however, that in respect of the works carried out directly by the contractor, it may enter into contract for the supply and installation of goods, plant equipment, road furniture, safety devices, and labor, as the case may be. For such work, for the avoidance of doubt, the parties agree that the contractor may subdivide the aforesaid length of 51% sections of the project highway. The parties further agree that all obligations and liabilities under this agreement for the entire project highway shall at all times remain with the contract. So, not irrespective of contracting, subcontracting the work, as far as the ministry is concerned, they will only deal with me. In the event any subcontract for works aggregate or such subcontract, any subcontractor exceeds 5% of the contract price, the contractor shall communicate the name and particulars, including the relevant experience of the subcontractor, to the authority. Prior to entering into such subcontract, the authority shall examine the particulars of subcontractor for the national security and public interest perspective and may require the contractor no later than 15 business days from the date of receiving the communication from contractor not to proceed with subcontract, and the contractor shall comply there. That's the about my obligation to inform. Now please turn over the page 241, Roman 4. It is expressly agreed that the contractor shall at all times be responsible and liable for all obligations under this agreement, notwithstanding anything contained in the agreements with its subcontractors or any other agreement that may be entered into with the contractor, and no default under any such agreement shall excuse the contractor from its obligations or liability under this agreement. However, in case of non-compliance of the contractor to its obligation for payments to the approved subcontractor, which is likely to affect the progress of the work, the authority reserves its right to intervene and direct the contractor to release such outstanding payments to approved subcontractors out of payments due for the completed works in the interest of work. I remain responsible with the authority. The only exception carved out is that if the authority feels I have unnecessarily delayed payment to the subcontractor, the ministry can direct me to make payment in the interest of work. That's the only exception. Now, I subcontract 49%. And you'll actually find that document at page 498. Yes. The petitioner before Election Lord is a Russian entity incorporated under the laws of Russia, which was granted this work.
Yes.
Now, let me see, 498 is a subcontract agreement dated 25th September 2020. Now, let me see, this is between the Joint Stock Company Industrial Association, which is the Russian entity, and a proprietorship concern by the name of Tenor Engineering, which is respondent number 5 before your lordship. It will be relevant not when I come to the arguments that this is a subcontract agreement between the appellant and respondent number 5. Now, please have the third recital begins with whereas was is now intending to entrust your lordship. Whereas was is not the appellant before lordship is now intending to entrust and assign the responsibility for the performance of the work allotted to them to the extent permitted under the contract with more than employer, which shall form integral part of the subcontract agreement. This exact execution will be defined under the design consultant and contractors define the detailed scope of work. Lakshmi, just please turn over the page at page 5. Clause 3. The said conditions contained in the main contract agreement between WAS and Ministry of Road Transport and Highways shall be read and construed as forming part of this contract, and the parties hereto will respectfully abide by and submit themselves to the conditions and stipulations and perform the contract on their part respectively. The scope of the original contract between WAS and Ministry of Road Transport will be applicable to the subcontract agreement for the work. So specifically, will not provide that you will be bound by the principal agreement. Now, please have a document which your lordship will find at page 647. This is crucial. I've shown your lordship that I get this in 2020. I subcontract respondent number 5 in 2020. Now, my lord, in the section 9 petition.
Well, 647 you wanted to show.
Yes, but that's what I'm showing you. 647 is a document which now respondent number 4 in his section 9 alleges that this is a document which respondent number 5 and respondent number 4 have executed amongst them. Just one more fact note before I go ahead with the lordship. Neither my principal agreement with Martyr nor the subcontract agreement has any arbitration clause. Let me just make a note of that fact. None of those two documents have that clause, arbitration clause. Now, my lord, in the section 9 petition, this document surfaces for the first time, wherein the respondent number 5, who is Hachang Tanang, alleges for the first time that on 29th July 2022, after I subcontracted the work, an agreement is executed by respondent number 5 in favor of respondent number 4, assigning the work which I have given to respondent number 5. That's the allegation. Now, please have page 647. Your lordship may see this is a document between Shri Daling Tatak, which is the proprietor of the tenor, who is respondent number 5, to whom I had subcontracted, and Mr. Hachang Tanang, who is respondent number 4, the writ petitioner in the section 9 petition. Now, lordships may have over the page at clause 4. Clause 3 first. That the consideration amount of the aforementioned project has been fixed at rupees 8.5 crores, which shall be paid to the first party as full and final settlement amount as stated above. Prior to execution of this memorandum of understanding, the second party do hereby acknowledge the receipt of the same, and the first party do hereby, please mark it, convey, transfer and assign all his rights, title and interest of the above said project under this memorandum of understanding. And 5 says that the first party hereby assure and declare, I don't know how this declaration is coming, that he is the conveyance deed holder and is the sole, absolute, exclusive and rightful owner of the aforesaid project, and he is fully competent and full right and power to sale and transfer the same. He is not the owner, blood. I have got the project. At best, tenor is my subcontractor. That the first party hereby absolutely assigns, conveys and transfer to the second party all her rights of ownership, titles and interests in the above mentioned project under this memorandum of understanding MOU. Now, please turn over the page at 649. Similar assertion is made in paragraph 11. That the first party assures the second party and declares that he is the sole, absolute, exclusive and rightfully owner of the above mentioned project under sale and is fully competent and full power, absolute authority and unrestricted right to sell and transfer. But just ignore all of this, blood. So this is the document which the petitioner in the section 9 petition places before the court, that this is the document which was executed by respondent number 5 in favor of respondent number 4. Number one fact, neither my principal agreement nor my subcontracting agreement nor this third agreement have any arbitration clause. Neither of these three have any arbitration clause, nor have they invoked it. I will come to the document in which they invoked it, but they have placed this blood. That's the reason I'm showing you. It is my case that this has come to my knowledge for the first time once they filed it, once I got to a copy of the section 9 petition. But the fact remains that none of the claims under this agreement could have been part of the section 9 petition, because there is no arbitration clause between us. In either of, even if I accept this agreement, there is no arbitration clause in either of these agreements. And of course, in my contract with tenor, the respondent number 5, there is a clear bar on subcontracting or giving it to somebody else. So this agreement will be in teeth of that. But again, at the cost of repetition, it would not matter, because this is not subject to arbitration at all. Now, please have one document which your lordships will find at page 518. So sorry. But because the Lordship knows we are a Russian company, that Ukraine war was going on. So we have an entity which is a wholly owned subsidiary in India, which executes a similar agreement with tenor. The date is crucial. They claim that tenor had already subassigned all its rights under the agreement to respondent number 4 on 29/7/22. Let's mark that date. Now this agreement, which I'm executing with tenor, with this only work, is 29/11/22. So if their assertion is right, that they had already assigned, tenor had already assigned the entire work to respondent number 4 in July 22, then this should have formed part of the agreement which is being executed in November 22. Nothing, Lord. Tenor does not make a whisper out of that I have already given up all my rights in favor of Rajang Tanang. Nothing. Absolute silence. Now, Mulats, the important comes is, these are 541. At the asking of tenor, because they are my subcontractor, and your Lordship may see this date, 20th January 2021, I appoint Hachang Tananglod, who is respondent number 4, the petitioner in section 9, as my site manager. We have authorized Hachang Tanang, site manager, tenor engineering. Please mark out site manager, Messrs. Tenor Engineering, to hand over 7 copies of APC agreement for the project as required in the project. Kindly acknowledge the receipt of the same. Now, please turn over the page at 542. And this was sent to the...
So the subcontractor appointed by your subcontractor was actually a site manager. Is that what you said?
Yes, that's what I'm saying. Lord, the tenor asked me to appoint him as a site manager. I appointed him as a site manager because he was my subcontractor. He requested for me, you appoint him as the site manager. I said, yes, all right. Now, please have 542 minutes.
Yes.
At their asking, I also appoint him as the project manager on my behalf. Lordship, may I have appointment of project manager? Yes, sir. Appointment of project manager. We have appointed Shri Hachang Tanang as the project manager for the month of February, March 21 for the project widening of so-and-so, which is the project in question of existing road to 2-lane standard road. And then this is irrelevant. But the reason I'm showing these documents, Your Lordship, is this, that because he was my project engineer, he was even sending my bills to the ministry. He had access to all my stamps, etc., everything. That's the submission I'm making. Now, please note the crux of the dispute is at page 544. Look, this is a document which respondent number 4 relies upon. Your Lordship, we just have this minute. As this is a document of 29 August 2024, claimed to be executed between me and Hachang Tanang, who is respondent number 4, the petitioner before the section 9. Now, please have note bottom of the page, clause 2. The second party is a class 1 legal category construction firm registered under PW. The second party has agreed to undertake the construction of remaining 10-kilometer work under above said work of the first party. So they say 49% I've already given to Tenor. He is getting additional 10%. I'm sorry, not 10%, 10 kilometer. So 10 kilometer will be approximately 24%. Because the total work is 43 kilometer. Please turn over the page. Let the second party desires to sublet the second party to perform and execute the remaining construction work of 10 kilometer stretch of the said project at an amount of 39 crores. This value will be important. The value of the project is 39 crore only without escalation and 52 crores with escalation in hold oblique retention amount. But has that not at the top of the page? Now, please have the heading on this very page, which is scope of responsibility and financial obligation. The second party shall bear full and exclusive responsibility for all financial obligations associated with the execution of the above said work, including payment to laborers and payment to the subcontractors. So the work he's doing, he says, he will bear. Now, please have turn over the page at 546.
You're disputing this.
Yes.
I'm saying that this is not a genuine document.
I'll answer. But there are 6 things I have noted. But I'll just let me show these 2 clauses and I'll come to what is the issue.
Here's an arbitration clause.
Here there's an arbitration. Before that, before that, 546. Payment. Upon the satisfactory completion of the work by the second party. But please mark note 1, it is subject to completion by them of the work and subsequent verification, acceptance, certification, and payment of bills by the Ministry of Road Transport. So 1, it has to be subject to completion. 2, the verification, acceptance, and certification has to come from whom? The question that I'm asking, it has to come from the Ministry of Road Transport. The first party shall make payment of the bills to second party within 2 days of the date of release of the bills from Ministry of Road Transport. 3 things. 1, completion. 2, verification by MORT. And 3, their bills will be released once I receive payment from MORT. 3 things. Now, please have the next clause. Note that the first party, after reduction of 4% from the total bills amount received from Ministry, shall make payment to the second party. Further, the first party shall hold 3% of the goods and service tax. It is further agreed that the second party shall submit all necessary documentation and certification required by the first party and of client MOT.
So this document you're saying is not genuine.
Look, I am saying it got signed from an officer, one who was not authorized, to under duress. I've written letters to that effect. I will show that. But I will proceed ultimately when I make my argument. I will proceed also on the basis that please presume for a minute that this document is correct. Then what is the effect? That will be also one of my submissions.
Yes.
And look, the arbitration clause, and look, before that, I'm so sorry, friend points out inside, but paragraph 4 on this very page, amount of mobilization given.
Yes.
The first party shall pay an amount of rupees 2 crores to the second party to facilitate mobilization and execution of the works. The second party undertakes to utilize this amount for the purpose of the works contemplated herein, misuse or diversion of the said fund shall be deemed as material breach of the agreement. Then over the page is the arbitration clause. Clause 6. In case of any dispute between the parties, the dispute should be settled through arbitration. Of Guwahati High Court, Itanagar. Yes. Now, before I take a look through other things, just a few submissions on this document. Please come back to page 544.
Yes.
Let's see the top of the page. There is a stamp which says serial number and date. Top right hand side column. Let's see the date. Is 31st August 24. So this stamp paper is purchased on 31st August. And please see the date of the agreement. 29th August is the date of the agreement. Even if you just see this bottom of this page, left hand side column, their signatures of Hachang Tanang, proprietor, the date of 29th August is mentioned. But I can understand somebody signing later after purchase of the stamp paper, but can't be prior. That's one. It says, that 10 kilometers is being given to them. The project is 43 kilometers.
This serial number that you say,
yes,
is it for the stamp paper?
It is actually the date.
Notarization date.
The date of notarization.
Date of notarization.
That's what I will instruct.
Because normally, subject to correction, is dates are written on the reverse
Backside.
of the
Website.
stamp.
If that is, but I'm thankful to my friend for correcting me. I will not do that. The second bullet, he says that he has been given 10 kilometers out of 43. But I asked myself,
See, you are in appeal against an
I am
order
conscious.
passed under section 9.
Yes,
Right?
yes,
There is some interim order granted.
yes,
According to you, the original agreement with your subcontractor, there is no arbitration agreement.
yes.
This document, according to you, is purportedly not executed
Signed
with
under coercion,
proper-
etc.
proper authority.
Yes,
But the fact remains until you get some order from some competent court of law,
yes,
this document remains.
yes,
Right?
yes.
Now, this document has an arbitration clause.
So I'm not arguing that this is not arbitrable.
Right.
That's not my assumption.
Right. Therefore, your only question is that this interim order which was passed, it is contrary to the agreement itself.
No, that's not my assumption. So let me give you a logic. What is my arguments? What are these?
What was the direction of the...
So the direction is that I have been restrained from realizing bills from North, from the ministry. That I can't give my bills to ministry and ministry can't pay me. That's the direction issued. When the project is still continuing,
Then how will the subcontractor receive the money? How are they supposed to get their bills?
they will get it from me. Once I get payment, if everything has been verified. If I don't get money from more, how will I pay them? The entire project will come to a standstill. I don't have the entire money to keep putting in the project and not get a penny out of more. Lordship knows these agreements, these contracts are executed by we keep getting money from the our principal employer and we keep putting it in the project. That's how we work. But that's not what instead of not doing anything else, the court has restrained me from even getting money from the ministry. That's my the first issue which I will raise before Lordship says whether at best their claim is that they are entitled to 50 crores from me. That's the entire claim. I ask myself, where have the principles of Order 38 Rule 5 been considered by the court below? May have 38.5 with me, and whether the impugned order even shows an iota of consideration on Order 38.5, and that issue is covered by my respectful submission by judgment of the Supreme Court. I'll just place it. Now, please have Order 38.5 with me for a minute. CPC. Yes.
Where is the impugned order here?
Yes, the next one. That begins at page 41. And I will show to you, Lordship, the primary consideration which the trial court places upon saying that they have completed the work is a completion certificate issued by respondent number 5, who has nothing to do with this project anymore, as per them. Please have 38.5 with me for a minute. Where at any stage of the suit, the court is satisfied by affidavit or otherwise that the defendant is marked with intent to obstruct or delay the execution of any decree that may be passed against him, is about to dispose of the whole or any part of his property, or is about to remove the whole or any part of his property from the local limits of jurisdiction of the court may direct the defendant within a time fixed by it, either to furnish security in such sum as may be specified in the order, to produce and place at the disposal of the court when required the said property, or the value of the same, or such portion thereof as may be sufficient to satisfy the decree or to appear in show cause why it should not furnish security. Similar, 3 conditions have to be fulfilled. 1, the court has to be satisfied that there is intent to obstruct or delay the execution of the decree. 2, that I was about to dispose of whole or any part of the property, or I was about to remove the whole or any part of the property from the local limits of the jurisdiction of the court. Now let's just have one judgment of the Honorable
What let us first understand what was the direction of the court.
Yes, that should have
The
that.
order.
Yes, I'll read I'll show the include order first, then I'll go to the law. Now, please have look paragraph 5 first.
Page number?
Look, it begins at page 41. Look, para 3, the court notes the agreement between us, between me and Mort, between me and Tenor, respond number 5.
Which you dispute.
No, this is the Tenor agreement.
This is the subcontract.
This is the subcontract agreement. I admit that document.
Right.
Then let's may have 4. It is submitted that subsequent to for the ease of business, it was decided that the parties that a direct subcontract, this is the one which I disputed, that a direct subcontract be executed by was in favor of the petitioner. Accordingly, on 29th August 24, an agreement was executed between was and petitioner for completion of the balance work, being a stretch of 10 kilometers. Clause 3 of the agreement provides that upon receipt of the bill payments, was will direct the payment to petitioner within 2 days. Clause 6 of the agreement provides for resolution of dispute. Pausing here for a minute, the court skips, probably was misled or something. It has not been noted that it is subject to verification and completion of the work and verification by Mort. Now, please have 5. The petitioner accordingly mobilized men and material and completed almost 98% of the works to the full satisfaction of the authorities and respondents 1 and 2. The respondent 2, in fact, issued a completion certificate. Please mark this bullet. Completion certificate expressing satisfaction of the works executed by the petitioner and endorsing that the entire stretch has been completed except a bridge over the rivers Subansiri, which is allotted to the other party. Now, I'm pausing here. This is a completion certificate issued by Tenor. Now, your Lordship, notice this 10 kilometer is not even as per their case between me and respondent number 5, respondent number 4. Tenor has no role to play. Even as per their case at the highest, the agreement is between me and respondent number 4. This 24 agreement which I dispute. Tenor is neither a party. It is their case that I gave them this 10 kilometer stretch straight away. Now, what the court relies upon is a completion certificate issued by Tenor. And I'll show how Tenor is in league with this Hachang Tanang Mulad. Now, please Mulad have paragraph 6. It is submitted that the dispute cropped up when the petitioner started demanding payment for the works done by him, but the respondents began avoiding the issue on one pretext or the other. Surprisingly, on 14th February, WAS sent a letter to the executive engineer of PWD stating that it has decided to revoke the authority vested upon the petitioner. It was informed that only the representative of WAS would henceforth raise bills and make correspondence. Notice dated so-and-so was also issued by WAS to the petitioner, contending that the authority vested on the latter had been revoked. Being aggrieved, the petitioner made numerous requests for payment and also reached out to the authorities. The petitioner also discovered that WAS had adopted dubious methods to obtain the tender by submitting fake bank guarantees. The State Bank of India, via a communication dated so-and-so, made an explosive revelation that the BGs which are provided for obtaining the work went fake. It is submitted that WAS had secured the work by submitting forged documents, then engaged local contractors to get work executed, making no substantial investment. Thereafter, WAS in collusion with Tenor was attempting to siphon off the entire money by depriving the petitioner of its registration. It is further submitted that in the meantime, the equipment and machinery which the petitioner had invested in terms of the agreement with Tenor was still lying on site. The petitioner thus demanded rental compensation for the said machinery. However, WAS in collusion with Tenor reached out to the deputy commissioner, alleging attempt by Tenor to demobilize machinery, suppressing the fact that the petitioner shouldered the responsibility of PMIs. In respect of the same, deputy commissioner thereafter issued an order restraining demobilization of the machinery from site. Upon learning from the illegalities, the superintending engineer on 30th April directed not to forward any bills in respect to the project to the ministry. However, despite that order, of fresh payments were made by referring to backdated bills. The same is apparent from the memorandum of payment annexure 17, wherefrom it is seen that despite the order of the superintending engineers, payments in respect of billing period from 16/11/24 till 30th April 25 has been processed. In view of the above, the petitioner has approached this court for an interim measure under Section 9, firstly to secure the amount in dispute by restraining, processing, releasing any other bills in favor of respondents 1 and 2 in respect of the project, and secondly, to restrain demobilization, alienation, and creation of third-party rights in respect of the machinery and equipment lying on the project site. Now the finding of the court begins from paragraph 11. After hearing the learned counsel on behalf of the petitioner, I have also perused the annexed documents along with the petitioner under Section 9. It is observed that with clause 6 of the agreement executed between WAS and petitioner, it is agreed between the parties that if any instances of dispute is aroused between the parties, the same is to be settled to arbitration with the jurisdiction of Itanagar Permanent Bench of Guwahati High Court. It shows that this arbitration agreement between the parties and application to Section 9 is maintainable. It is observed from the documents produced by the petitioner that the petitioner has invested considerable amount of money and effort in these completion of the project, and the petitioner is entitled to receive the bills for the work carried out. But pausing it for a minute, there is not one document in the entire petition before the Section 9 which shows that they have carried out the work, much less completed. How much is the work done? How much is the amount invested? Not one document except for one single page I will show you, which talks about their plant and machinery of about 5 crores. I'll show that. As the respondent number 1 by letter dated so-and-so issued to the executive engineer PWD informing that it's been decided to revoke the authority vested upon the petitioner. It was informed that only the representative of WAS would henceforth raise bills and make correspondence. A legal notice dated 16th April was also issued by WAS to the petitioner, contending that the authority vested on the latter has been revoked. Above actions of respondent number 1 clearly show that it's trying to deprive the petitioner from his entitlement to raise bills, though he has completed this work. Please mark it. In view of the above, it is observed that there is a prima facie case against respondent number 1 in cause of action in favor of the petitioner. It is further observed that bank guarantee produced by respondent number 1 while obtaining the work is fake, and the event of disbursement of pending bills, the same can never be recovered, and there is every possibility of misuse of the same depriving petitioner. It shows that the balance of convenience is also in favor of the petitioner. It is the principle of law that the petition under Section 9 is maintainable even before initiation of arbitration proceedings, where there is an arbitration agreement, and this court has jurisdiction for passing appropriate orders for convenience of upcoming arbitration proceedings and for protection of rights of the parties. Issue notice to the respondents for their appearance before this court and to show cause why prayer shall not be granted, restraining respondent number 1 from realizing any further bills in connection with the project. In view of the materials available in the case record, it is observed that there is prima facie case with balance of convenience in favor of the petitioner, and it's also observed that the event of realizing of the further bills before the disposal of dispute between the parties to arbitration, the petitioner may suffer irreparable loss and injury. Hence, the facts and circumstances of this case advise the court to pass an ad interim order restraining respondent number 1 from realizing any further bills till the next date fixed. So this is the interim order passed. Now, Lord, the primary consideration which the court had was that he has completed the project. Now, please have that completion certificate with me. That your Lordship will find.
What happened on the next date?
Lord, I'll tell you, Lordship, one interesting thing happened. Tenor files an application seeking their deletion from the project, from the Section 9 petition on that day. The learned judge dismisses that deletion application. Now, Lord, Tenor is in complete league with this respondent number 5. They file a petition before your Lordship, my Lord, in a revision, and your Lordship in that petition have stayed further proceedings in Section 9 petition. So they have an interim order now, but the proceedings can't go on in Section 9. The Section 9 court is now cannot do anything. Please have that order with me for a
Yeah, part of the
no, because we got to know after the filing. And I will show Tenor is in complete hand in glove with this petitioner. They get an order and then file a petition seeking stay of the proceeding, because the stay order will then continue. Lordship may have the first page, blood. This is a petition by Tenor. The application was that there is no relief sought against me and hence delete me. The learned court and its wisdom said, no, you should continue because you are an integral part of this. And then, after considering all of that, if your Lordships may have, page 5, paragraph 12, your Lordships. On being prima facie satisfied that there is no relief as such has been sought against the petitioner by respondent number 1 in the interim, the proceedings in arbitration case number so-and-so pending before the Court of Learned District of Utah is hereby stayed until further order that is to be passed by this court. So they obtain an order by somebody who is in collusion with them, files a petition before Lordship's blood, and the proceedings before Section 9 is stayed.
Then what orders do you want in this matter?
That the interim order has to be suspended.
What interim order?
That I cannot realize bills with my employer.
How will I undertake
This,
work?
this part of the matter is before it's being considered under the CRP matter.
But that is only whether tenor has to remain a party or not. Only to that extent. I'm not concerned whether tenor remains party or not. It is irrelevant for me. It is a list between me and Hachang Tanang. Even as per the pleading of Hachang Tanang, this dispute only concerns that 10 kilometer, which tenor has nothing to say. Absolutely nothing. It is as per them an agreement between me and Hachang Tanang directly. Tenor is not in picture at all. Even as per the case pleaded by them.
Yes.
Please have note annexure 16, page 651.
So see, we are not disposing of the matter today.
Yes.
It's come for notice.
Yes.
The caveators are there. We'll complete the notice part and we'll see.
No, I am requesting that in the meanwhile the order be suspended.
No, that's what we need to consider.
Yes, that's the reason that I am showing these documents to your Lordship, that if I can convince your Lordship that this is complete travesty of justice, I will request your Lordship to suspend the order in the meanwhile. Just one document before I take your Lordship further.
The order is already, the proceedings are already suspended.
Yes, proceedings, I am requesting the order to be suspended, that I can't.
The question is that it was open for you to go before the court, district court, and file necessary applications, modification, or recalling this order that these orders have been passed on documents which are not existing or incorrect or anything like that.
So I can't do it, that's my problem. Today, there is a stay by the court.
Can't do it. Therefore, you appear in this matter and get it vacated.
So that,
how do you want, and how, see the proceedings are stayed by a coordinate bench.
Yes.
And then you want a modification of this order when the proceedings are otherwise stayed.
Yes. If I can convince the Lordship that this order cannot sustain in the legal principles, then certainly it will be my submission before Lordship that
overreaching the orders.
No, that will only consider whether Section 9 proceedings can go on. My challenge to you before Lordships is an interim order on merits. It is my.
Therefore, the first question to you is that why didn't you go before the court and modify it? To which your answer is because it is stayed, you can't go.
I was not served on that date. Till the time I got served, this order had come to be passed.
When appeared,
no, I had not.
By the time you were.
No, I had not. This is an ex parte order, Mullah. On the first day, without notice to me.
No, that's all right. But when you filed this appeal, yes, you are aware that an order has been passed.
Yes.
What stopped you from going before the court and getting this order modified instead of filing? Because you have a remedy of filing an appeal, we are not questioning that.
Yes.
These issues could have been thrashed out before the court itself.
I bow down, the problem here is that the trial court has taken a view which is completely contrary to all canons of law. With all humility, I will
it's an ex parte view.
Yes.
Which you can get it corrected by appearing.
Of course. I could have got it correct. The problem is that I have been left in a lurch wherein I can't go to the trial court because now the proceedings have been stayed. And this order, I have been restrained from realizing my bills with MOD, and I can't today work on the project. How will I not spend money? PWD has given me a deadline to complete this work by 31st October. I will not. How will I do it without any money?
It's all right, but to effectively pass an order modifying it in a proceeding which is again suspended by an order of this court, I think the proper thing to do is to get both these matters heard together.
I was only saying that if your Lordship could consider this, whether this order can actually sustain the light of scrutiny.
That would be the outcome of some hearing at some level after the parties exchange whatever pleadings or whatever you want.
That of course is there. Yeah. But if I can show you Lordship, just two things before your Lordship, on a prima facie view and nothing else. Just two things. Just please have just page 6.
Then if you convince me,
yes,
I am just thinking aloud that what would be the effect of an order modifying that particular order when the proceeding is again stayed by this.
If I can,
these proceedings being stayed.
Yes,
I do not know whether it was brought to the notice of the coordinate bench that there is an order passed against this. Appears to have not been brought up.
Maybe.
So therefore, it is necessary for you to. You still have an avenue before this court
go and file an application to say that you can't stop the proceeding because of this, or because you have filed some application, or because an appeal is pending. It will lead to further confusion, as I can see it.
But can I only make one and subject to that right do that whatever is to be done in that petition? Not I my respective submission at the end of the day with this. In the meanwhile, not let me realize bills from my employer. It can't be that in a claim where at best my subcontractor has against me.
No. Mr. Counsel, you're Mr. Jain.
Yes.
I appreciate or would like to appreciate your anxiety that it's a contract matter. But you see, this is a sticky patch which you have got into for reasons best known to you, because the avenues were still open. This order appears to have been passed on 28th.
Yes,
28th of August. Cursory glance in the order reflects that there is no discussion that that order of the district judge has passed us. If there's an interim order restraining, whether he's a party, not a party, etc., all these things are not gone into. So perhaps had this material been placed before the court,
maybe the court may not.
Maybe the court may not have passed this order.
But I can only say.
But fact is that there
there is an order today. That's in operation. I can't ask your lordships to vary that order, because of course
we can't do that.
Your lordships not in of that order.
To modify that order, essentially, will amount to overreaching this proceeding, besides the proceeding in the district court.
With all humility at my command, when I say this, if your lordships agrees with me and suspend this order, my respectful submission is we will have no bearing on the other petition. The reason is this, but with my limited knowledge. That petition is only
the proceedings are already suspended. That's what I'm trying to tell you.
Yes, but the proceedings in section 9 are suspended. So, the only reason I'm saying this, is that petition concerns only whether tenor has to be a party to the proceedings or not. That's the only limited.
Mr. Counsel, you have to appreciate the difficulties or the complexities of the matter. We are concerned with passing an order on the basis of the submissions or the government's made.
Yes.
Here is a case, what you are asking us to do will add to the further confusion, because you are concerned with your bills.
Yes.
You are not concerned with this proceeding or that proceeding, because according to you, you are essentially concerned with your bills. Whether you release the payments to the subcontractor or not is again on a different sphere
between me and them.
Right. The fact remains that what does the court do in this petition which is filed, and a petition section 9 which is filed before the district court on the basis of an agreement which you say is non-existent?
But I'm saying please assume that this is correct. I will presume that the agreement exists.
Correct.
Let me assume on that today I'm in a section 9 against an interim order. I'm saying please presume that this agreement was existing.
But therefore we have to give now that the caveator is there, we have to hear the caveator, and perhaps he may like to file some pleading.
He may want to, right. I can't stop him. Right. And your lordship would of course have given that liberty because he's a respondent, but he will get that liberty. But in the meanwhile, is the problem which I am beseeching your lordship with only, that whether without considering the principles of order 38 and without considering the documents which are there, could the court have passed that order? In the first place is the question I'm beseeching your lordship. Please assume whatever they are saying is right. Please accept that everything that every document which they place before the court is a correct one. Whether the court have overlooked the provisions of order 3825, and that's what the Supreme Court has commented. May I just place that for us.
Assuming we agree with whatever you say,
yes,
we interfere with this order on the ground that this principle, order 38 principles have not been followed. Matter is remanded back. Yes. We may even add a rider that the parties will maintain status quo till the matter is decided. It doesn't help
status quo here because it's not a.
I know, but it doesn't help you because you see, essentially, you are before the court because your bills are blocked.
Yes.
Plain and simple.
Yes, it's absolute.
Right?
Yes.
Now, what is the right? What is the claim between you and vis-a-vis the other party? Is before the respective courts to decide.
Yes.
Right?
Arbitrator, if they agree on, if they are able to.
Therefore, to assuming that we suspend or vacate this interim order and permit you to receive all the bill,
subsequently, this claim in the petition under section 9 may become redundant.
Well, it may not. The reason is this, because I am not a fly-by-night operator.
We are not saying you are.
No, I'm
We are not saying you are.
I am doing projects, at least 10 projects for various state governments.
We are not saying you are even remotely. We are not even suggesting that.
Yes.
We are just trying to understand the fact that there are 3 different petitions pending before 3 different courts.
Yes.
Between the same parties.
Yes.
Should it not be consolidated so that the reliefs can be pinpointed and the matter can be decided in the shortest possible time?
He's saying that this is a money claim ultimately which they have
Right.
against me.
That's right.
Not add in a money
As
claim.
I can see it, if this order gets vacated, this order passed in the CRP,
Yes.
modified,
Yes.
Subject to, of course, you filing your applications and appearing in the court, then this matter should be examined, or we can take it up together, subject to.
Of course, that of course your lordship can consider, but that's your lordship's prerogative. But I am only saying, Lord, if in the interim.
All right. Anything more you want to submit?
Yes.
Before you rely on the judge.
Yes, 2-3 things, Lord. We have 651.
651.
Yes. This is the document which they rely upon to show that the work has been completed. Now, please have the top of the page. Who has issued this document? The lordship may see it is on the letterhead of Tenor Engineering. Lordship sees that.
Yes.
This is to certify that the work construction of so-and-so in the state of Arunachal Pradesh and Arunachal Pradesh package of so-and-so and the quoted bid amount of 33 crores, 333 crores, as secured by the bidder in i.e. main contractor was, and the contractor 100% on back-to-back basis to us and further subcontracted on back-to-back basis by us to Hachang Tanang, wide agreement dated 29 July 22. That is the first 49%. Lordship, just skip that. And please mark the next line. The work has been successfully completed back-to-back basis by subcontractor Hachang Tanang, proprietor so-and-so, Lower Village, with the full satisfaction of the department as per specifications, except for a Subansari bridge valued at total billing of 14.5 crores, which was given by main contractor to another party. Now, let's just may have the bottom of the page, second last paragraph. The work cost of so-and-so, Subansari bridge value of 14.5 crore plus escalation value of contract price has been completed, satisfactory without any report, dispute, litigation on time slotted to subcontractor Hachang Tanang, as per MOU dated 29 July 22. Till here, there is no problem because there is no arbitration clause till 22 has been completed. Please have the next line, which is very crucial. This includes works from 196 to 206 completed by Hachang Tanang under direct agreement between dated 29th August 24 with our sanction. So, two things. Tenor is now saying that even the 10 kilometer which Tenor has nothing to do. It's even as per their case, it's a direct agreement between me and Hachang Tanang that I certify, Tenor is certifying that Hachang Tanang has completed even that work. But I ask myself that question, where was the occasion for Tenor to say any of this thing that they have completed that work? And I have shown to your Lordship, as per the agreement, this certificate has to come from ministry, not from Tenor. And Lord, this secondly, this 10 kilometer is now being, so under the agreement, there was no description of which 10 kilometer. Now, innovatively, it comes 196 to 206. This is the first time that this document is coming defining the 10 kilometer, which is non-existent in the agreement. And your Lordship may have the work experience certificate is issued only for official purposes as per specific requests of the subcontractor and please mark and consent of the lead contractor, that is me. Where is that consent? He says, I have given consent for issuing this work certificate. This is a complete red herring, Lord, which has been created only to show to the court that the work has been completed. In fact,
I will show to your lordship documents after documents which show that the work is not complete. Now please have 657. This is a document of January minutes 25.
Okay, we have understood in sum and substance whatever you're reading. Let us hear the other
Just
side.
one judgment can I show to your lordship on 38.5.
Yeah.
How has the Supreme Court interpreted that?
Essentially, what you're agreed is that Section 9 petition, there was no satisfaction by the court.
Yes.
The property is likely to be disposed
Yes.
of or anything like
Yes.
that.
Without that satisfaction having been
All right, not so many in so many words, but the property here are the bills, are the money we received.
Yes.
There's no machinery or anything like that.
Yes.
So therefore, all right, let us see.
Yes.
Excuse me. Yes.
Now, if your lordship may have paragraph 3, because at the outset, so sorry.
Yes.
At the outset, we required to prove that in the present case, the dispute is with respect to key purchase order, namely purchase order number 1 to it appears that the appellant served a notice upon respondent number 1 by notice dated 11 June 21, claiming a loss of so owing to the defective quality of cable supply. The notice was replied by respondent number 1 by reply so thereafter respondent number 1 served a legal notice 13 July 21 on appellant claiming for outstanding payment 1.50 crores. That the appellant, while communication dated so invoked the bank guarantee by way of performance bank guarantee, that thereafter the appellant invoked the arbitration on 26 July 21. Immediately on the next day, respondent number 1 filed 2 applications under Section 9 of the Arbitration Conciliation Act before the Commercial Court at Ahmedabad, another application before the Commercial Court at Kochi. Application of Section 9 filed by respondent number 1 was regarding 3 bank guarantee, which is subject matter of the case. At this stage, it is required to be noted that by the time any further order could be passed, the bank realized the payments under bank guarantee. Under that, the Commercial Court passed an order under Section 9 to secure the amount and directed the appellant herein to deposit the amount of respective performance bank guarantee, which as such has been invoked and for which payments are already made by the bank. The order passed by the Commercial Court under Section 9, directing the appellant to deposit the court in the amount of respective bank guarantees pertaining to purchase orders 1, 2, and 3 was the subject matter of appeal before the High Court under Section 13. By the impugned judgment, the High Court has dismissed the said appeal and has given rights to the present appeal, having heard learned counsel appearing on behalf of the respective parties. And in the facts of the circumstances, more particularly when bank guarantee is already invoked and the amounts under the bank guarantee is already paid by the bank much prior to Commercial Court passing the order in this case. And looking to the tenor of the order passed, it appears that the Commercial Court had passed the order under 9(2)(e) of the Arbitration Act to secure the amount. We are of the opinion that unless and until the preconditions under Order 38(5) are satisfied, and unless there is a specific allegation with cogent material, please mark that, to defeat, with cogent material, unless prima facie the court is satisfied, the appellant is likely to defeat the decree award, which may be passed by the arbitrator by disposing of the property, and or in any manner the commercial court could not have passed such an order in exercise of powers under Section 9. At this stage, it is required to be noted that even otherwise, there are very serious disputes on the amounts claimed by the rival parties, which are to be adjudicated upon in the proceeding for the arbitral tribunal. The orders which will be passed by the Commercial Court in application of Section 9 is basically and mainly by way of measure. It may be true that in given case, if all the conditions of Order 38 Rule 5 are satisfied, and the Commercial Court is satisfied on the conduct of the opposite of the opponent party, that the opponent party is trying to sell its properties to defeat the award that may be passed and or any other conduct on the part of the opponent party, which may tantamount to any attempt on the part of the opposite party to defeat the award that may be passed in the arbitral proceeding, the Commercial Court may pass an order, appropriate order, including the restraint and or other appropriate orders to secure the interested parties. However, unless and until the conditions as mentioned in Order 38 Rule 5 CPC are satisfied, such an order could not have been passed by the Commercial Court, which has been passed by the Commercial Court in the present case and has been reaffirmed by the High Court. In view of the above and for the reasons stated above, the present appeal succeeds the impugned judgment and order passed by the High Court and the order passed by the Commercial Court in application 9(2)(e), directing appellant to deposit the amount
already invoked are hereby quashed and set aside. However, at the same time, to protect the interests of the parties, we direct that the appellant herein shall furnish an undertaking backed by the resolution of the appellant's company before the commercial court that in case any award is part by learned arbitrator in arbitration proceedings, the same shall be paid honored by the appellant, subject to the challenge of the High Court. But clearly, the Supreme Court says that you cannot. This was a case where the restraint sought was to give bank guarantee or the amount, secure the amount in dispute. Here, the restraint which has been sought is further for me to realize my amounts from my employer. How will it's a matter of national importance, but it's a highway project. If I don't get my money, how will I execute the project? There are documents on record where their assertion that the project is complete is completely incorrect. The ministry has sent to me, written to me again and again. If you just may have those documents with me for a minute, please have those documents. Page 657, first. The Lordship saw that document completion certificate is of January 25. And please have this document at page 657 is 21st July 25. And your Lordship may see, sir, this is to bring to your notice that progress of work is very slow manner last month, despite of repeated directions from the authority. Please mark the next line. Physical progress as per MPR March 25 was 95.26%. Physical progress as per MPR June 25 is 95.84%. So completion is 95.84%. And now Lordship may have, and next paragraph, there is an achievement of 0.5% in last 3 months, which appears very poor progress of the work and is disappointing, as you are aware that the revised target date set by the ministry for completion of the project as per approved DOT by so-and-so, dated so-and-so, is 31st October 25. Work may not get completed in target date if persists such slow pace of work. So I have to complete this project by 31st of October. And your Lordship may then have page 660. Page 660. This is a document of 28th of July, 25 minutes.
Yes.
In the Lordship, the second paragraph, as per a monthly progress report, the financial progress was 94.17%, and the cumulative physical progress was 97.16%, marking an increment of 1.9% between January and April. The figure of 0.58% stated in your correspondence does not accurately reflect the recorded progress. It is admitted the pace of work is not as required by site. This was done due to some reasons beyond our control. This is our reply, namely disruption of work, various student unions. As on date, we have completed highly critical elements, including open and covered drains. Highway work is almost complete, except major bridges so-and-so. Launching of street girders has been started on this. We reaffirm our commitment to extended completion date dated 31st October.
Yes.
So I am saying I will complete this work by 31st of October. But if I don't get my bills, how will I pay my my laborers, my contractors? How will I complete this project of national importance, my lord? The other issue, my lord, I am raising before your lordships is this, that the only document which they place on your lordship's record and which your lordships will find as 639. To show that they have carried out this work worth 50 crores is absolutely zero. Not one document before your lordships, my lord, that they have carried out this work. Now, please have this document of 613 at 639. This is a document of April 25. Now, let me have enclosed here with the detail of rental bill and pay for so-and-so Arunachal package under Mrs. Hachang Kanang. And please see the bottom of the page. Total amount is 5 crore 53 lakhs. So the only detail which they give to your lordships, my lord, in a section 9 petition, on their own letterhead, is about 5 crores. And please see also this, my lord. Number 1, Beijing plant 26 months. So this will predate 2024 agreement. So these all are not under the 2024 agreement. These are all at best under the earlier agreement, which there is no arbitration clause. And just please have three things, two documents with me, 634. But 26th April, they write to me saying that there are dues. Let me just have the bottom of the page. Tenor has said that if I keep quiet, you may give me some money in the end. Sorry, I'm not able to position to accept that. I did not work in your full knowledge so as to be responsible for getting monies paid to Tenor to reach me. Many of the accounts shown as deductions from dues have nothing to do with this project. And look, he says in the third paragraph, I'm attaching performer invoices. Now, please have page 636. Are the three invoices he places before the section 9 quote. One, this letter never includes, this letter was received by me through email. These three invoices did not accompany. There was a separate invoice of 50 crores, not that apart. Just please have this. These performer invoices. The first is 16 December 24. And your Lordship may see, it is done to JSC India Private Limited, which is the Indian entity. Not the Russian entity, my lord. And lord, it only says works contract services. Nothing as to when, how, what work they did. But I asked myself that question, lord, without absolutely any proof of any work having been done by this respondent number 4 before lordship. Could the section 9 court have considered whether it has actually done the work which is claiming, lord? Just because Tenor issues a completion certificate, which is in league with this respondent number 4, how did the court come to this conclusion that it has completed its work? I have always said, at whatever you have, you deal with the Tenor. I have nothing to do with you. How does the court, one, the court says prima facie case. No, in my respectful submission, 38.5, prima facie case, irreparable loss, balance of convenience do not come in. Those are not considerations under 38.5. Those are considerations under 39.1 and 2. Even otherwise, to consider prima facie case, is there a document before your lordship showing that they have executed this work which they claim approximately 50 crores? Two, even on balance of convenience basis, that's the paramount consideration. The balance is, there are two rival claims. One, they are claiming amount from me, and there is an amount which I have to claim from my employer. But does the balance of convenience not dictate that I be permitted to raise my bills and get my amounts? If they succeed in their claim, they will get that amount from me. I am willing to give the same undertaking which the Supreme Court asked for in the judgment which I have just placed before Lordship in Sanghi Industry. Even on first principles of prima facie case, balance of convenience, I am not doing projects worth 2,000 crores for various governments. It is not a case where the trial court has come to a conclusion, I will run away, or I can run away in a night. I'm still doing this project, and I'm doing at least 10 other projects. I've detailed them in my petition. And just one more fact, I have to maintain this road for 10 years. And I will get amounts from yes, just one provision I want to show to Lordship is section 20A of the Special Relief Act, which has now been brought in by the 2018 amendment. Specific Relief Act. capital A.
Yes.
So it says no injunction shall be granted by a court in a suit under this act involving the contract relating to an infrastructure project specified in the schedule. While granting injunction would cause impediment or delay in the execution or progress or the completion of the infrastructure project. Now, Lordship has the schedule with me. If schedule note first entry, the Lordship sees one transport, and the very first one is roads and bridges. And this provision in respect to a section 9 petition has been considered by a Delhi High Court judgment. If a Lordship permit, can I place that before Lordship?
Yes.
We have paragraph 7. At this juncture, it is also relevant to state that sections 20A and 41HA of the specific express the legislative intent not to grant injunctions relating to infrastructure. A was that the injunction would purpose and objective your commitment was to promote for investment and build investment. The infrastructure sector. Public-private partnerships have long supported long delay cost overrun. One cannot deny the fact that infrastructure has a significant role in the growth and development of the nation and helps in the development of overall production of the nation. Hence, an obstruction in the development of infrastructure would be negative consequences for the whole nation, leading to stagnancy in the economy and the downfall of the market. The amendment was aimed at improving India's global standing in terms of enforcing contracts and ease of doing business and would further increase FDI. Any public work must progress without interruption. Thereby, the role of courts in this exercise is to interfere to the maximum extent so that public work projects are not impeded or stalled. My considered view, Section 20A and 41HA of the SRA squarely applied to the case, and an injunction would tantamount to further delaying the infrastructure project. But even in my case, if such an injunction is granted, it will amount to delay in the project because where will I spend money from in the project? Project will have to suffer. It's in the interest of the state government, it's in the interest of nation that public at large, that this order needs to be vacated.
Yes.
One HA, I just want to read, 41HA says, an injunction cannot be granted if it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision for relevant facility relating thereto or services being the subject matter of such. So, based on all of these principles, my respectful submission, because I have to complete this project by 31st October, considering the nature of the project, it is my respectful submission that the order may be suspended.
Yes.
That's it.
Yes, Mr. Decker.
Wait, please, Your Lordship. My Lord has already seen that the order impugned is ad interim in nature. So whether an appeal under 37 would at all be maintainable or not is a question that Your Lordship has to decide. Now, if Your Lordship sees section 37, my Lord.
Yes.
Section 37 says, notwithstanding,
Yes.
Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders and from no orders to the court authorized by law to hear appeals from original decrees of the court passing the order, namely, perhaps B has been sought to be invoked, granting or refusing to grant any measure under section 9. Now, I must admit that the judgments are not in accord, and there is yet to be a an order by the Supreme Court clarifying the position whether B would cover also an ad interim order. Now, there are judgments of certain high courts which have said that yes, it may include an ad interim order, but there are others which have said that it is only the final order under Section 9 which is appellable under Section 37. In fact, the division bench of the High Court of Meghalaya has held otherwise and has held that the proceedings under Section 9 have to conclude so as to for there to be a final order which is appellable in which is appellable under Section 37. My Lord, I'll just place that judgment, my Lord. Lord, in fact, the first submission that I would have made is that the appellant before your lordship should approach the trial court, my lord, because there's so many new factual disputes that have been raised, which in my humble submission cannot be raised in this appeal.
Yes, we have the judgment. Paragraph.
Now, if your lordship has paragraph 33 of that judgment, my lord.
Yes.
Para 33, my lord, the appellants admittedly have neither filed a show cause nor contested the application under Section 9 on merits, but had instead filed an application under 39(4) seeking vacation of the ad interim order dated so and so on the ground of suppression of facts and for dismissal of the Section 9 application on the question of jurisdiction. Section 37(1)(b) of the Arbitration Act provides that the granting or refusing to grant any measure under Section 9 is appellable. Therefore, in the light of this provision, what first needs to be examined is the nature of the interim order and as to whether it would amount to a final order or a step towards the final interim order under Section 9. A plain reading of the order dated so and so clearly reveals that the interim nature of the order, in as much as it is only an ex parte, but liberty was granted to the appellant to seek appropriate orders for modification of the same. Now, if your lordship skips over to para 34, does the purport and nature of the above quoted order leaves little room to arrive at any other conclusion, but that it is an order which is purely ad interim in nature and is not conclusive as to the interim measure or release prayed for under Section 9 of the Arbitration Act. The order dated so and so, however, has not been put to challenge before the court, and the appeal, notwithstanding any submissions made to the contrary by the appellant, is limited to the challenge to the order dated so and so, rejecting the application under 39(4). In this context, the other aspects to the appeal being maintainable by virtue of the proviso to Section 13(1)(a) of the Commercial Court Act, wherein Order 43(1)(r) has been mentioned, needs to be looked into. Coming again to Section 37 of the Arbitration Act, which alone can be looked at for the purpose of filing appeals against orders granting or refusing any measure under Section 9, it is found that Order 43 does not find any mention in this provision. What follows, therefore, is that if finality in a Section 9 application is to be arrived at to make any order pass thereon appellable, the facts and merits of the application filed by the respondent under Section 9 have to be gone into. In the instant case, there has been no final adjudication of the Section 9 application, nor does the impugned order finally decide the same. The appellant, as noted above, did not file show cause or affidavit to contest the same, but has instead filed an application under 39(4). The decision in the application under 39(4) has not conclusively decided the Section 9 application, thus making it unappellable under 37(1)(b) of the Arbitration Act. Now, like I said, my lord, there are, of course, judgments to the contrary, where perhaps Bombay High Court has held that even an interim order needs to be is an appellable order, but that question still remains, my lord, whether such an order would be appellable under 37(1)(b) or not. Now, even otherwise, my lord, considering the fact that so many disputed new facts have been brought in the appeal, my lord, I would, in my humble understanding, suggest that ideally these issues have to be raised before the court, exercising the adjudicating the application under Section 9.
Which can be done because of the interim order you have got. suspending the proceedings.
That comes as a surprise to me, even, my lord, because I had lodged a caveat and I don't understand how the proceedings were stayed. My lord, I can understand the proceedings being stayed qua tenor engineering, my lord. We will take appropriate steps, and perhaps for that, me and my learned senior friend would be in tune that the proceedings should go on, my lord. But like your lordship has already observed, now the only way out is to seek modification of that particular order passed in the civil revision petition, my lord. Now, my lord, coming back to the main thrust of the argument that has been advanced by the appellant, is that the provisions of Order 38, Rule 5 have not been complied with, my lord. Now, if your lordship has that judgment of my lord, Sanghi Enterprises, my lord, which my learned friend had relied on, my lord, the difficulty with this judgment is this, my lord. Your lordship will mark the date of the judgment. It is dated 30th of September 2022, my lord. Has your lordship seen it on the first page, my lord?
Yes.
My lord, just 15 days prior to passing of this judgment, my lord, there was another judgment passed by a coordinate bench of the Supreme Court, which had said that the parameters of Order 38, Rule 5 will not even apply in a proceeding under Section 9. That is the judgment of SR House Private Limited versus ArcelorMittal Nippon Steel India Limited, my lord. Now, if your lordship marks the date, this was decided on 14th of September 2022. So this is prior in point of time, but was not considered in the judgment of Sanghi Enterprises. Now, if your lordship has para 44 of that judgment, Sanghi Enterprises, most respectfully, doesn't really deal with the prior judgments, my lord. It's a very short order. It said that the parameter, the test of 38.5 applies equally to proceedings under Section 9, my lord. But however, SR, which was delivered 50, I'm sorry,
Referring to para?
para 44 onwards.
44. Yes.
In Jagdish Ahuja versus Kupino Limited, the Bombay has your lordship found it, para 44.
Yes.
In Jagdish Ahuja versus Kupino Limited, the Bombay High Court correctly summarized the law in para 6 extracted herein below. So as far as Section 9 of the Act is concerned, it cannot be said that this court, while considering a relief thereunder, is strictly bound by the provisions of Order 38, Rule 5. As held by our courts, the scope of Section 9 of the Act is very broad. The court has discretion to grant thereunder a wide range of interim measures of protection as may appear to the court to be just and convenient, though such discretion has to be exercised judiciously and not arbitrarily. The court is no doubt guided by the principle which civil courts ordinarily employ for considering the interim relief, particularly under 39(1) and 2 and 38 Rule 5. The court, however, is not unduly bound by their text. As this court held in Nimbus so-and-so, as the learned judge then was, the court, while exercising power under Section 9, must have due regard to the underlying purpose of the conferment of power under the court, which is to promote efficacy of arbitration as a form of dispute resolution. The learned judge further observed as follows: just as on one hand, exercise of the power under Section 9 cannot be carried out in an uncharted territory, ignoring the basic principles of procedural law contained in the Code of Civil Procedure, the rigors of every procedural provision in the Code of CPC cannot be put into place to defeat the grant of relief, which would subserve the paramount interest of justice. A balance has to be drawn between the two considerations in the facts of the case. Now, if your lordship has para 47, Section 9 of the Arbitration Act confers wide power on the court to pass orders securing the amount in dispute in arbitration, whether before the commencement of the arbitral proceedings during the arbitral proceedings or at any time after making the arbitral award, but before its enforcement in accordance with Section 36 of the Arbitration Act. All the court is required to see is whether the applicant for interim measure has a good prima facie case, whether the balance of convenience is in favor of the interim relief as prayed for being granted, and whether the application has approached the court with reasonable expedition. If a strong prima facie case is made out and the balance of convenience is in favor of an interim relief being granted, the court exercising power under Section 9 should not withhold relief on the mere technicality of absence of averments incorporating the grounds for attachment before judgment under 38(5). Proof of actual attempts to deal with, remove, or dispose of the property with a view to defeat or delay the realization of an impeding arbitral award is not imperative for grant of relief under Section 9 of the Arbitration Act. A strong possibility of diminution of assets would suffice. To assess the balance of convenience, the court is required to examine and weigh the consequences of refusal of interim relief to the applicant for interim relief in case of success in the proceedings against the consequence of grant of interim relief to the opponent in case of proceedings should ultimately fail. Now, my lord, even otherwise, my lord, like the only limitation is it should not be extended beyond a particular limit, my lord. Now, in the case at hand, my lord, if your lordship sees it's a reason, it's otherwise a well-reasoned order. I need not reiterate the scope of an appellate court while dealing with an appeal in against orders of discretion, my lord. But your lordship has already seen that all the facts have been dealt with, my lord. And in fact, what had weighed in the mind of the trial court was that they had a bank guarantee issued in favor of Morth, which eventually turned out to be fake. I mean, which is why there was a high possibility that I would not be in a position to sort of realize my dues, even if I am successful at the in the course of the arbitral proceedings, which are of course yet to commence, my lord. Now, here, my lord, the two things, my lord, which perhaps takes care of both the arguments. If your lordship for a moment will have page 633, my lord. The appellant had submitted a few bank guarantees as performance security, my lord. Now, of course, in the appeal, they've tried to say that it was all the doing of tenor. But ultimately, like the appellant has itself pointed out, that they remain sort of answerable to the PWD. Now, my lord, out of those bank guarantees, my lord, this is a letter from the State Bank of India, my lord. Para 2, if your lordship sees. With reference to the caption BGs, we hereby confirm that the BGs are fake and they have got no relevance to the standard norms and of issuance of BGs in our bank. The official letterhead used by the miscreants and the signature of the officers are also fake, and no officials were posted in our branch during that tenure. The matter is of utmost concern, and we request you to initiate suitable action against the fraudsters, and if so desired, arrange for sensitization and awareness program for your department at your place in considerate coordination with us for aversion of such frauds in future. So this was the, now of course they want to, this was furnished by the appellant. This was furnished by the appellant. However, now they're saying it was a doing of tenor engineering. We have no hand in this, and we've already rectified this mistake. Now, so this is another factor that had weighed in the mind of the learned trial court, when the trial court says that yes, I've seen the BGs itself are fake. So therefore, if they realize the amount, they've got nothing to lose. There'll be no security even. Now, based on this, my lord, now, a lot of argument has been made that how do I even complete the works if the bills are not released? Now, if your lordship has page 641, Lord, the appellant has suggested that it is because of the order impugned that they're not able to realize the bills, and which is why the project is at stake. Lord, I'd like to show that even without the impugned order, the superintending engineer had passed a specific direction not to even sort of send the bills for realization.
Demobilization.
I'm sorry, Madam. I'm sorry, page 643, if your lordship. Lord, this is an order dated 30/4/2025, Lord. Now, this was a letter by the superintending engineer to the executive engineer. This office has received a complaint concerning the authenticity of the bank guarantee submitted for the above mentioned project. Accordingly, the matter is currently under re-examination to verify the genuineness of the said bank guarantee. In view of the above, you are hereby directed not to forward any bills related to this project to the regional officer MOD till further order is issued from this office. I don't think anything has been placed on record as to whether this order has been modified or not. So regardless of whether this section 9 order stands or not, my lord, the PWD itself has said that there should not be any forwarding of bills. So this entire argument that it is because of this order by the district judge that the project is at stake, or that an infrastructure project is being impeded, is factually not correct, my lord. In fact, given the conduct of the appellant, the PWD authorities have themselves decided not to sort of forward any bills. Now, what prompted the learned district judge to pass the order was that despite this order, on the following page, if your lordship sees page 644, I don't know how they managed to do this. Notwithstanding the order passed on 30/4/2025, there was further release of payment. Here on the last column, if your lordship sees, the billing period 644 and extra 17. The billing period is 16/11/2024 to 30/4/2025. So if 30/4/2025 is the end of the billing period, naturally the payment has gone thereafter, my lord. This is an undated document, my lord, which is why our specific case was that you were still trying to sort of realize money, notwithstanding the order of 30/4/2025, by raising backdated bills. And that is another factor that had weighed in the mind of the district judge. Now, a district judge, while passing the order, impugned, my lord. Now, my lord, lot has been said about.
Yes, carry on.
My lord, lot has been said about as to how there was no authority vested on Tanner Engineering, etc., etc. However, there's an agreement on record directly between the appellant and the respondent number 4, and the authenticity, of course, has been questioned, my lord. But that is an adjudication which perhaps the arbitral tribunal has to do in the course of time, my lord. But if your lordship has page 564, my lord, that's an extra 13. Lord, now this is addressed to the team leader MSV International. This is by the appellant company, Lord. With reference to the aforementioned project, and our letter cited so and so had authorized Sri Hachang Tachang project manager to so and so in relation to the caption project. Moving forward, the company has decided to revoke, withdraw Hachang Tachang's power and authority with immediate effect, that is February 14, 2025. So, my lord, for there to be a revocation, my lord, there has to be a vesting of authority. Now, so therefore, this goes to show that my involvement is sought to be questioned, my lord. However, by their own showing, my lord, there was some authority vested on me. Now they're trying to show that it was just merely in the capacity of a project manager, etc. But my involvement is established from their own letter, where they said that we are revoking the past authority granted to the respondent number 4. So, my lord, given all of this, now that the order passed is an order passed, is a discretionary order passed, my lord, and given the fact that the scope of the appeal is very narrow, my lord, they can perhaps argue that there was perversity on record, my lord. But however, to point out that perversity, if there was any, they have to first approach the court and state the facts which they're trying to argue before the appellate court, my lord. And given the fact that this is an ad interim order, the powers of the appellate court, in my respectful submission, will be all the more circumscribed. Now, I actually need not place any judgment on this, but there's a recent judgment that has come up, which is the judgment of Ramakant Tambalal Chosky, where again the scope of an appeal against such discretionary orders have been examined, and because this is ultimately akin to an order of injunction, and therefore the scope of an appeal would also be akin to an appeal under Order 43 of the CPC. So I'll not trouble your lordship with the judgments, but with the details of the judgment, but paragraph 19, 20, 21 to 19 to 25 would be relevant, my lord. I'll just mark the judgment and hand it over. And what exactly is perversity has also been explained from paragraph 34 to paragraph 39, my lord. So unless they show that there is some perversity on record, or it has been sort of decided by ignoring the settled principles for grant of an interim order, there can hardly be an interference, that too at an ad interim stage, my lord. Lord, like I've already submitted, my lord, there are possibly two views available as to whether an appeal against an ad interim order passed in a Section 9 application is appellable under 37B, my lord. But even otherwise, my lord, even if we view it from the scope of the Order 43, my lord, then also it doesn't really call for an interference at this stage. Now, insofar as the stamp paper issue is concerned, like your lordship has already seen, the date of issuance of the stamp paper is usually on the flip side of the page, and the date that has been reflected is actually the date of notarization, my lord. Now, all other things, my lord, I'll reserve my argument since.
So see, now the difficulty here is, if we have to accept your argument that this is an injunction, temporary injunction, therefore no final view has been given by the court, the obvious thing to do is to go and approach the court, seek a modification, recall, cancellation of the order. Fact is that there is a civil revision petition filed whereby the proceedings are stayed itself.
My lord.
This order needs to be vacated, where the appellant is not a party.
My lord, I would to answer that, my lord. To answer that, my lord, why should my interim order be sort of sacrificed because of the revision, a stay order obtained by Tenor Engineering? Lord, with utmost respect, both the parties, the respondent number 4 and appellant, may seek appropriate modifications, my lord. Because a third party has sort of got an order for stay of the entire proceeding, should my interim order be vacated? Can that be a ground to vacate my interim order if I'm otherwise successful in obtaining that by placing the relevant?
Vacating or not vacating, the question is that assuming we relegate the appellants to go and file necessary application for vacating, the fact remains that the proceedings itself are stayed. by orders of this court, bench.
True, Malay. True, Malay.
So
That's a
unless
difficulty.
that order needs to be modified to permit the proceeding
Correct.
before the trial court.
Correct. I'm all
Now-
with the appellate insofar as getting that order modified is concerned. Your Lordship may also record my submission, because ultimately, Your Lordship, that order which was challenged in the civil revision petition, that application was contested by us. Because ultimately today the appellant may say that it's Stanor and Hachang Tachang who's in collusion. On the other hand, I would say that it's Stanor and Was who are in collusion. So this factual dispute has to be resolved by the the Section 9 and in the Section 9 proceedings. So may I suggest, my lord?
Yes.
My lord,
Yes.
Your Lordship will maintain the interim order for now, giving us liberty to both the parties to sort of seek modification of the order passed in the civil revision petition. And the only modification that we need as on date is that the proceedings, even if stayed, should be only qua Messrs. Tanor Engineering. Because ultimately, we've also been contesting the stand of the Tanor Engineering, because Tanor Engineering perhaps wants an exit. Because and while Was and Hachang Tachang keep fighting it out in court.
But isn't there another aspect that you are required to address for?
My lord.
That you are admittedly the subcontractor.
True, my lord.
You are the subcontractor.
True.
So you have executed some amount of work with Hachang or anyone else, by yourself or to somebody else.
Yes.
Is there a provision under the contract agreement that the payment for the work that you have executed can be unilaterally released to you?
No, I'm not saying that for a moment. My lord. My prayer is very simple, my lord. I'm not saying that the payment should directly come to me. All I'm saying that the PWD is in custody of a particular amount, which perhaps I would be entitled in the event of me succeeding in the arbitral proceeding. And that is the very object of Section 9, because Section 9 says...
What is the quantification of this amount? Where does one find that? What is that amount?
My lord, we've been raising invoices after invoicing. Says we can bring all of that on record, my lord. And ultimately, my lord, they've already released the major...
Without that being on the record, how have you made a claim for preservation or stay of the property
I've included all of that in the Section 9 application, because my learned friend has already shown that I have a claim for the rental compensation. In fact, post this, my lord, we've also issued notices under Section 20.
Therefore, where the contract does not lay down any provision to say that you would otherwise be entitled for a payment directly in the event the main contractor refuses or declines or fails to release your payment. There is no provision. So unless even if we take that your claim is correct of being entitled to some payment for some work done, that money has to come from the main contractor, which is the appellant.
True, my lord.
Now, unless the appellant submits their bills, which has been restrained by an application filed by you, how do you propose to get your claims sorted out?
My lord, to answer this query, my lord is aware of the text of Section 9. My lord. It doesn't really talk about who's going to release or whether I can withhold payment or not. But the words used are preserving the amount in dispute. My lord. Now that order of preservation.
So what is that amount in dispute? Where does one find it, so far as you are concerned?
My lord, what
is that amount in dispute?
There's an amount in dispute, my lord. I can quantify that, my lord. But the problem here is, my lord, this amount will not be one solid figure, my lord. It can comprise of various components, including...
Mr. Dekar, you are aggrieved and have sought a protection under Section 9.
True.
That the property which is a part of the dispute, which will ultimately be sorted out or attempted to be resolved by arbitration, should not be dispensed with by the other party. This is sum and substance of your apprehension for Section 9.
Exactly.
Now, what is that property?
Property, my lord. In fact, that I should address that straight away, my lord.
It is not a case. It is not a case that the entire amount which this appellant is supposed to receive is something that you can have a claim over.
Well, we don't know how much is in store with the PWD because they've been releasing one after the other.
That you don't need to know. You just have to quantify your claim and place
We'll
it before the
quantify
court.
that.
This is the amount.
Well, the problem
Where
here
have you done it?
Well,
Where
I've
have you
already
done it?
done. Well, it will come have my Section 9 application, my lord. What has happened here is, my lord, in fact, we had more prayers in the Section 9 application, and the court said that for now will not grant you all of the reliefs because ultimately, if your lordship sees the
We are just referring the order passed by the trial court. The trial court has referred to many things, but it has not referred to any property so as to say the quantifiable amount which you claim you are entitled to, and subject to conclusion or subject to such orders being passed in the arbitration proposed to be held. It's not there. So on what basis the protection is being granted? Because the NIT is very clear. It's not a case that you can directly go and submit your bills. Your bills must come through the original contract.
Yes, ma'am.
So you are not being replaced by the original contractor. You are only a subcontractor, and you will do 5%, 10%, whatever that amount is, whatever that is permissible. So according to you, you have completed either the entire work or a substantial part of the work. And you are now apprehending that the amount which you are supposed to get this company, the main contractor, may refuse to grant you and utilize the money elsewhere. And therefore, even if the arbitration award is in your favor, ultimately the funds coming from the government, there will be no fund left to pay you. That's your case before the Section 9 petition.
Yes, yes.
Right?
Now,
so, unless you quantify the amount, that out of this so-and-so 5 crore, 10 crore, 50 crore, 100 crore, you are entitled to 20%, 30%, whatever.
Yes, my lord. My lord, my friend has the exact quantification of data, my lord. Another aspect, my lord, I just quickly point out, my lord. What has happened here is, my lord, if your lordship sees the agreement, initial agreement between me and Tanor Engineering, my lord, your lordship will see that major chunk of the investments that I have made is in the form of EMIs for the plant and machinery. Now, these plant and machineries have now been utilized in the project. The agreement clearly says so, my lord. It is for the appellant to dispute in the course of time.
In the CRP, the appellant is not a party. Is it a party?
I have not even been served with a copy of that application, my lord. I was surprised when
this number 2, just above 80.
All right.
Number 2.
So, my lord, so the major chunk of the investment that goes in the project is the cost of EMIs that I shoulder for the plant and machinery that are in place, my lord. Now, therefore, your lordships will recall that there was a demand made that you pay, if you're using my plant and machinery and not giving my dues, you pay the rental compensation thereof. So ultimately, to quantify that.
Come back to you. We will come back to you in a minute. Now, Mr. Jain, assuming we stay the order, if you present your bills, how do you propose to protect the interests for the time being, assuming this is to be correct, of the respondent?
What I said, report vacated the order and directed to give an undertaking. Will you give that undertaking straight away?
No, this undertaking is itself not sufficient. But you have to give a bank guarantee. You furnish a bank guarantee.
That
the Supreme Court said in the matter of.
I'll show that. That is not applicable. I'll show the Jacinda Banerjee judgment. That is on a different issue.
Right. But the question we are asking you is, if we have to modify this order, then you have to give some guarantee to say that in the event the trial court finds that the trial court order is sustained and arbitration is there, there's something to arbitrate about. We can't make the arbitration redundant. There are so many ifs and buts here. The basic agreement itself is questioned. If subsequent agreements are questioned, if the PWD is refusing to accept your bill.
No, that I will answer. Your Lordship, give me 2 minutes, I will answer.
Even now we are required to issue a notice to the PWD.
That Your Lordship will do, but otherwise they are not really concerned with this dispute between me and.
They're not, but they're concerned with release of the money.
Yes, that's the whole problem. Let me just base things up which I want.
No, we don't want you. We have heard the council extensively. We are not going for a final hearing. It's only a question of. It's only at the notice stage.
Yes, that's correct.
And to the plum on the cake is this order by the coordinate bench that the proceedings itself are stayed.
That had not been probably not. Yeah. But
No, that sort of prejudices us also because we have further prayers to press before the Section 9, in the Section 9 application. My Lord, may I say?
We can take it up tomorrow. You complete your instructions and come back.
just give me 2 minutes and we'll come back.
You have to give us work for 2 minutes. We'll how many matters?
7.
All right, we'll carry on with the other matters. We'll come back.
I'll just come back.
Yes. Mr. Deka, he wants some instructions from his clients. We'll follow up the matter in a way.
Very good.
Item number 11 and 12.
Yes, my friend Mr. Tapin, who appear on the other side, madam, personally requested me to apprise your lordship for tomorrow, madam. Otherwise, madam,
for tomorrow,
madam.
There's some affidavit you are required to file. Reply affidavit.
Madam, that has already been filed, madam.
Already been. What is the matter about?
Madam, termination, madam. If lordship periods, madam, otherwise, madam, matter is very simple. I undergone, madam, the basic trainings for 5 months, madam. In the meantime, madam, my service has been terminated. Only on the grounds, madam, there is a the police case registered against me, madam, which is not actually correct. And on one, madam, the occasions, madam, the case was registered against me. And madam, at that relevant point of time, I was juvenile, madam.
See, tomorrow you are going for a disposal,
madam.
Then you must be ready with all the arguments. I have no difficulty otherwise.
Madam.
But once we hear the matter, we don't want the matter to be again deferred on the ground of facing some judgment or some material. You are ready for a final disposal hearing. What is the prayer that you want?
Madam, reinstatement.
So reinstatement will require examination of the records.
Madam, records, everything has been done.
So do you expect everything to be done in one day?
Madam, pleadings are completed. Pleadings are completed.
Reinstatement on what basis?
Reinstatement, madam, wrongly, madam, on the wrong presumption, madam, my service has been terminated. Madam.
What is the stand of the respondent?
Respondent, madam, non-disclosure of some material facts in the attestation form, madam. At the time of filling up a form for the post, some, madam, the false information has been given, madam. That is the only crux of the case.
False information regarding what?
Regarding my first character antecedent, madam.
So you had some criminal background.
Criminal background at the relevant point of time when I was juvenile, madam. Then, madam, the juvenile, as per the Juvenile Justice Board, madam, JJ, madam, it is clearly protected that the person cannot be a disqualifications for that adverse, madam, anything. So,
right. Tomorrow,
madam. That is the only malad issue, madam.
List again tomorrow.
Requested
by the council.
Item number 13.
APP, any APP here? Let's call an APP. this is jail appeal. Against the judgment and order dated P2020 past 10 SGSC within bracket POXO case number 20 of 2016 by the session judge cum special judge POXO Act Sainik District Pasighat by the same judgment the sentenced to suffer imprisonment for 10 years. By the same judgment and order, where two defendant number 1 was sentenced to suffer rigorous imprisonment 10 years for the offense under section 376 within bracket N IPC read with section 4 of POXO Act and be a fine of 5,000 only, and it is also fine to undergo further simple imprisonment for 3 years. No. The appellant was also sentenced to suffer rigorous imprisonment for years for an offense under section 8 POXO Act and pay a fine of 3,000, and if people to undergo months, both the sentences were directed to run concurrently in respect of the accused, who was accused number 1, the judgment. So this present appeal is prepared on behalf of the accused number 1, the so and so. Trial court records.
My lord, I'm sorry, madam, I'm late, your lordship. Your lordship, here, your lordship, the legal aid counsel need to be appointed.
That's right.
And secondly, my lord, they have only filed the judgment copy, my lord. They need to file the application, proper application.
But this is the jail appeal.
Yes, your lordship. But your lordship, application need to be accompanied because your lordship, the party who are the necessary party that has to be implemented, madam.
That's right. So therefore, legal aid counsel has to be appointed.
Yes, ma'am.
Advocate Morik Bagra.
She is present, ma'am.
Present? You are here? Okay. Your name was left out on the last time when we appointed 12 or 13.
Yes, yes.
So you are the last one in the list left out. Signing you a matter.
Okay.
His appoint legal aid counsel is appointed to appear before on behalf of the appellant. So the registry will hand over all relevant papers. Will be that right? The legal aid counsel appointed. Once the trial court records are received, the legal aid counsel will also be permitted to make copies thereof. We are not putting it in the order, but you may have to prepare a memo of opinion by.
Yes, sir. Okay.
Just after 4 weeks.
Yes, sir.
Mr.
Here, the matter.
It is APP.
Yes, sir.
APP appears for the state.
Oblige.
Item number 14.
May your lordship.
Yes.
Lordship, the health department has filed their affidavit in oppositions and copy has been served this morning. So I have gone through the affidavit of petitions, rejoinder is not required. So may I pray this matter may be listed for admission hearing on 23rd of September, Your Lordship.
Learned counsel for the petitioner submits that the affidavit of the respondent have been filed, and the petitioners do not want to file any like what agree as agreed to. The matter be listed for admission hearing on 23rd.
Yes, Your Lordship.
September.
Lordship. Obliged. For admission hearing.
Admission.
Obliged.
You're Mr.
Yes, I appearing on the
Yes, I appearing on behalf of health.
Yes.
Standing council health.
Yes, sir.
Item number 15.
Absolutely, Lordship. This contempt petition, direction was that the district committee and the state committee has to be constituted, and the petitioner has to be considered under the compassion under 5%.
Service is awaited on
Yes.
respondent 1. Anyone appearing for respondent 1?
I think 1 and 5 is same. 1 and 4 is same, Your Lordship.
1 and 4. So they're two different persons. One is secretary, one is the director.
Yes. But then the main in this party is a secretary.
1 and 4. Oh, sorry. One is the secretary land and the other is also secretary land.
Yes.
You are representing who?
I'm representing respondent number 4 and 5.
Secretary.
The present secretary, Sri A.K. Singh, and the director, land management.
And who was the earlier secretary?
Pankaj Kumar Jha.
But the notice has gone to him. He also is required to appear. Somebody has to appear on it. Yeah.
Yes, I think
unless you file an application saying that his name may not be struck off.
then my lord,
Yes. Learned counsel for parties, service report on respondent 1 is awaited as per office note. Respondent number 4 and 5 represented by Mr. So counsel and respondent
Number 2.
3 and as so appears for respondent number 3. The respondents represented by the council may consider filing their response in the contempt petition list after 3 weeks.
Item number 16.
Mr. Lordship, on behalf of the petitioner side, the learned senior counsel Subbu Goyang sir is some personal difficulties and unable to appear, and he pray for the adjournment. And moreover, this is the same nature of the cases going on before the Honorable Supreme Court. So it is humble practice, Honorable Court may adjourn this matter.
Similar matter is pending.
Yes.
Before the Supreme Court.
Supreme Court.
Yes, counsel. Counsel at the bar submits that the issue raised in the present petition is pending before the apex court. You have the case numbers, field numbers, etc.
No, my lord. Only the instruction, verbal instruction is there. No written record is.
The SLP or civil appeal number not available with the counsel for the petitioner. He is permitted to place it before the court the next day. This matter again after
4 weeks. Obliging.
And learned counsel, the so and so appears for respondents.
Respondent number 4 on behalf of M. Carton.
Respondent 4 and
Respondent number 2, Your Lordship.
respondent.
Obliging.
Item number 17.
Your Lordship, here, Your Lordship, in this case, pleadings are complete, Your Lordship.
Pleadings complete.
Yes, Your Lordship.
The counsel of the bar submits that the pleadings are complete and the matter be listed for admission. It's again on after 1 week.
Oh, Your Lordship, 2 weeks.
2 weeks.
Item number 19 and 20.
My lord, in item number 19, these are connected matters, 19 and 20. Now, in the main writ petition, my lord, we have already filed our affidavit in opposition. Today, the case has come because of the interlocutory application, which is item number 19. Now, my lord, maybe there was some communication gap. Maybe it is my fault. I could not communicate properly to the Honorable Court. In interlocutory application, my lord, the petitioner, the principal relief which is there in the writ petition, by way of interlocutory application, he is seeking that principal relief. Earlier also, my lord, he filed an interlocutory application, which is IA 12 of 2024. That is also listed. In that IA also, the same prayer was made, and Justice Surana rejected that prayer, saying that this relief is the principal relief in the writ petition and can't be claimed by way of interlocutory application. So that is it, my lord. I need not file any affidavit. Affidavit in opposition I have already filed in the writ petition.
Is the prayer in the main writ petition?
Oh, yes, my lord.
When the subject matter, my lord, let me submit, my lord. When subject matter is that, my lord, there are 95 point certain hectares of land who have been illegally encroached by the National Hydroelectric Power Corporation, my lord. So that area was not, though it was surveyed, but later on it was dropped out. So our lands are totally now going to be submerged because of the non-action on the part of the authority.
We are disputing all this.
If both councils agree, then we fix it for hearing.
Well, let it be for hearing. My lord, it may be fixed for hearing. But my lord, next week it will be difficult because my lord, there are pending cases over here also. And my lord, they have not filed any affidavit.
You are not to physically come here. You can use the same module that you are using it now.
My lord, it will be difficult, my lord. Next week there are pressing engagements.
Unless you want to come here, which is of course.
My lord, it's always a pleasure.
Very nice place to be.
My lord, it's always a pleasure to argue in the new building. But my lord, next week there are pressing engagements. My lord, it will be very difficult for me. And they have not filed any affidavit in reply. If they don't want to, I have nothing to say. Matter is to be heard.
Do you want to file any reply?
No, my lord, yes, within short period time, if that they continue the earlier affidavit, we file it, my lord, rejoinder.
Want to file?
Yeah.
How much time do you want?
Within a week.
Then we keep it after what, 2 weeks?
Let it be on 23rd of September, my lord. My lord, could it be on 23rd of September? I will be there physically.
Good for you.
23rd.
My lord, as per the convenience of my learned senior, my lord, it will be difficult for the petitioner, my lord.
Oh.
Since 2023, he is facing a lot of problems.
When do you want it? Tell us.
My lord, after a week.
After 1 week?
Yeah.
So it has to be on 16th or 17th like that, Mr. Gwari.
My lord, if it is 16, 17, it can be on 23, 5 days. What hardship will come to them?
Oh, that is for you.
Since 2003, you have been taking
all right,
all the
for 5
time.
days. If
All
it is
the time.
17th or if it is
Every
17th
time
or
you are taking
23,
adjournment.
All right.
we are not taking
fix it
adjournment. Our affidavit in opposition was filed much earlier. It was
We
in the
fix
month
it
of
You have
June.
not supplied this affidavit of opposition
Nothing
to me
surprise.
also.
Absolutely. This is. Well, I'm sorry. What did you say?
So it is
No,
anything.
affidavit opposition you have filed, but you have not served the copy.
Well, the junior is standing there. You ask him.
Then I don't
I'm
know
not
whether
supposed to give you
junior
the
is there
copy.
or not.
You ask the junior.
All right. Let it be on 17th.
Lord, could it be on 23rd, my lord? It is Tuesday. It's a hearing day. It's a matter of only 5 days.
No, it's a question of the urgency filed by the writ petitioner. So he has expressed some urgency.
My lord,
Let it be on either 16th or 17th, whatever date is convenient for you.
there are part-hand matters here also. That's why, my lord, 17th.
That's
There
the
are
pleasure
part-hand
of
matters.
being a busy council.
My lord, have not, my lord. Mr. Son should accommodate. It's a matter of
I
only
have
5
been
days.
accommodating since
You are not.
2023.
All right.
You
We are
want to file
keeping it on.
rejoinder. You have not filed rejoinder.
All right. Then
And
we'll fix it on 18th. 18th?
My lord,
18th
Let
is a
it be on
Thursday.
19th. Let it be on 19th in that case.
No. See, then we might as well have it after 22nd.
22nd, my lord.
No. He is objecting to it. He wants an early date. You give us a date between 15th to 18th. Any date. Third counsel for parties. The matter in the counsel for the petitioner seeks liberty to file reply.
My lord, 17th.
Accordingly, the matter be listed for admission on 17th of September. 17th. The counsel, so Mr. P.K. Tiwari, senior counsel, assisted by Mr. appears for respondent number 5. Learned government advocate for 1, 2, and 3. DSGI. So appears for the applicant.
Right.
Yes.
Pass over matter, item number 10.
Yes.
Lord, may I submit one thing, man?
Yes.
Lord, even I had a word with my clients, my lord. My lord, this order staying the proceedings, they are also anxious, and I can understand the anxiety of the appellant also. Now that the proceedings have been stayed, my lord, both of us perhaps would be in some sort of difficulty. My friend perhaps will not be in a position to press for vacation of the order, and I, my lord, cannot press for the prayer number D in my section 9 application because my plant and equipment is under distress, according to me. Of course, that could be objected. So may I humbly propose one thing, my lord? If the CRP is taken on board tomorrow, both the respondents, contesting respondents are already
Taking up taxes along with the CRP and call for that file also. Then probably if we are able to conduct the lodgings, then
All right. Let it be on Tuesday.
Please.
Wednesday. All right. Heard counsel for parties. Even this is an application, this is an appeal filed against the order.
But the order dated
4
June 25.
4/6/2025 passed in arbitration. Should be arbitration case, I think. Arbitration
number
number 0/2025 passed by the district judge, Court of District Judge, UP, Arunachal Pradesh, whereby under Section 9 of the Arbitration and Conciliation Act, filed by the applicant, who is private respondent number 4.
4.
Four.
5.
Four.
4. No. 5 by 5. Sorry.
Or in the present bill, by the said order, there's an ad interim order was passed restraining the present appellant from realizing any further gain till the next date fixed in the matter for hearing. Being aggrieved by this order, the appeal has been filed under Section 37 of the Arbitration and Conciliation Act 6. The matter was heard at some length, and the Learned Senior Counsel, Mr. Jain, strenuously argued before the court that the principles required to be followed by a court while while granting an ad interim injunction under Section 9 application, namely the principles of Order 38, 5. Rule 5, is it?
Yes.
5 does not be followed as is apparent from a mere reading of the order. So, further submits that as per the NIT, is the appellant who has been awarded with the contract for construction of road, and there is a subsequent agreement with the respondent number 4 / the applicant in the Section 9 petition before the district court whereby the respondent 4 has been appointed as a subcontractor.
May not come as a certified.
Alright. Which, however, has been disputed by Mr. Jain, saying that this document is a questionable document. Be it as it may, he further submits that as per the contract agreement, it is only the appellant who is entitled to receive payments, even if for work done by the subcontractor as sought to be projected by the respondent number 4 of the district here. Where Mr. B.D. Decker, on his caveat appearing for respondent number 4, who disputes the arguments made, and both parties have relied on judgments of the apex court to submit that while Mr. Jain submits that the principles of Order 38.5 is required to be followed, Mr. Decker has referred to an earlier judgment, earlier precedent of the apex court to submit that these are not necessarily steadfast rules follow while deciding applications under Section 9 and the principles applicable under Order 39 would want it to be sufficient. So, however, in the course of the hearing, an order came to be placed before the court, an order passed in a civil division petition.
87.
7 of 25. Which was filed by the respondent number 5 in the present appeal against the respondent number 4. Stock reported bench by order dated 26/08/2025 has, while issuing notice, had stayed the further proceedings in arbitration number 2/2025 being the Section 9 application filed by the respondent number 4 before the district judge. Yeah. Stop. Consequently, the order impugned in the present petition, present appeal, being the order dated so and so passed by district judge, yeah, granting an interim order, ad interim injunction, which is sought to be vacated, which is being impugned in the present appeal. And as the entire proceedings are stayed, this court is of the view that it would be in the interest of justice to have the civil division be listed together with this arbitration appeal, so that both the matters can be heard and disposed of, and appropriate orders may be passed. They have agreed to by both counsel that the matter be listed on 10 of September.
Can I
List
request a
according-
copy if it's available with my friend? Of the CRT.
I don't have a copy. I just have the order. Even I don't have a copy of it.
You may apply for certificate.
We'll obtain certified copies.
Or it should not be that.
That one would like to dismiss that for particular schedule 1.
Section 20 capital A.
Section 20 capital A and section 41. Submit that matters of infrastructure or like construction of road, no injunction should be granted.
I'm so glad.
This according.
I'm so glad. Thank you guys for watching patiently.
But ultimately, this is exactly the question we asked you beginning of the argument. What's done?